All rise. The Justices of the Appellate Division, Supreme Court, First Department. Hear, all persons having business with the Appellate Division. Draw near, give your attendance, and you shall be heard.
Good afternoon, everyone. Welcome to the Appellate Division, First Department. I'm going to call the calendar. As you know, please only request the time that you actually believe that you need to argue. We are in possession of your briefs. We are fully familiar with your arguments, okay? So again, request the time that you think you need to argue, not the time that you would want in a perfect world. People v. Yeah, that's a no-no. Okay. People v. Robin Hamilton. 4-1 and 4. Okay, Jazavi versus ABM Industry Groups. I apologize for that. Five, 1 and 5. Carlos P versus Karen G. That is submitted. People v. Eric Cruz. 5, 1 and 5. Williams versus Citigroup. I'm sorry? 7, 2 and 7. Marine, New York Marine and General versus Westco Insurance. 5, 2 and 5. People v. William Parker. That matter is submitted. Continental Casualty versus KB Insurance. Do we have an appellant? Did you still wish to argue, counsel? Exactly. Thank you. Small versus the City of New York. Do we have another respondent? Okay. 5, 2 and 5. Oh, and 1. 5 and 2. Okay, so do 5 and 2, 5 and 2. Board of Managers versus Franklin Place versus New York City Fire Department. Who are you? Okay, so City, what do you want? And then we have, who else do we have? So, I'm sorry? All the respondents have 2 minutes. Appellant 5 and 2. People versus Forrest Richardson. That matter is submitted. Gulf LNG Energy versus SPA and NISI SPA.
For appellant 12, 7 minutes and 2, Your Honor.
6 and 2 and 6. Herrera versus Highgate Hotels. Nexus, I'm sorry. 4 minutes. 5 and 1, 4 and 4. People v. Bo Coleman. 5, 1, 5. Liberty Mutual versus Bonilla. That matter is submitted. 301 East 60th versus Competitive Solutions. 5-2, 5-2. First matter for argument, I'm sorry, no versus Local 983. That matter is submitted. First matter for argument, People v. Robin Hamilton.
Good afternoon. May it please the court. My name is Elizabeth Vastley, and I represent appellant Ms. Robin Hamilton. The underlying offenses, while very serious, do not warrant a life sentence for Ms. Hamilton. Her sentence should be reduced in the interest of justice to at least allow the parole board to consider her release after 20 years of incarceration.
So, counsel, what would be the special circumstances which would allow us or guide us in reducing her sentence?
Your Honor, a life sentence is understandably reserved for homicides or the most serious types of crimes. And here, while very serious enough to warrant 20 years, nobody was injured in this case. And Ms. Hamilton did not use a weapon here.
But she was with individuals who did. And I thought it interesting in your brief, you talked about the one complaint, and I don't recall which one that was, the one that was actually the subject of the kidnapping charge, wherein a gun was held to her head and they held her in the vehicle. And you said, well, you know, they only drove around for a bit and then they released her, which I thought was interesting. But then I read the respondent's brief, and apparently they really didn't drive around for a short distance. They drove from the Lower East Side to Midtown Manhattan, which as a native New Yorker, that's a distance. I mean, that's a considerable distance. So you kind of downplayed it in your brief, which I thought was a little bit interesting.
Your Honor, Ms. Hamilton does not dispute the seriousness of the facts, and that there was a drive, but at the same time, this is 20 years.
So again, what would be the circumstances, the special circumstances? They would be that at the time she's 45, that under the sentence that she was given, she would be 85 before she would be eligible for parole. Those would be the special circumstances?
That's right, Your Honor, so that Ms. Hamilton gets to spend the last years, hours, days of her life with her family and the community. For while she has done very serious things in her life, she's never physically harmed anybody. And 20 years is a serious sentence. And at 70, nearing 70, the age that if she were resentenced to 20, the risk of recidivism is very low. It's 4%, according to studies. And that, in addition to the fact that she has family.
Let me interrupt you, please. So the defendant was 45 years old when this happened. And we have, what, 2 robberies committed 30 minutes apart with kidnapping, the kidnapping of one, as was detailed by my colleague. Given the fact that this defendant has 21 prior convictions, including 17 violent felonies, given her age at the time of this incident, why would, I'm going to the same issue, why would a reduction in sentence be appropriate in this case, where, other than her age, other than the fact that she would be older when she gets out, where are the extraordinary circumstances?
Your Honor, life sentences are reserved for cases where there were a homicide, someone was killed, someone was permanently disabled. And in this case— Is there anything in the record about her exemplary behavior, helping others while incarcerated? Is there any indication of life-threatening illness or anything like that at all? At one point, Your Honor, she was helping formerly incarcerated people, HIV positive, re-enter.
That's before she got—
That is before, Your Honor.
So, no.
There's nothing in the record about her current behavior, but I'll reserve the rest for rebuttal, but the court would want to motivate her to be on her best behavior, to not incur tickets, so she would have a chance outside of prison again.
Thank you.
Good afternoon, Your Honors, and may it please the court, Emily Galt on behalf of the people. Defendant is not deserving of a sentence reduction here for several reasons. First, the facts underlying defendant's robbery and kidnapping scheme were horrific. No, she didn't murder anyone, but Brandenburg, who was kidnapped, was held in the car against her will. A gun was pointed at her head. She was driven around, pleading to be let go. So these facts and the lasting psychological effects she caused her victims warranted the sentence that she received. Second, defendant is a persistent, violent felony offender who has unapologetically engaged in a life of crime since 1993. It's clear that none of her prior prison terms had any deterrent effect on her. And lastly, defendant already received a 12-year sentence reduction. She's not deserving of anything further.
Counsel, isn't a sentence, however, of 38 years to life, shouldn't that be reserved for instances where someone is injured, that someone is killed, those circumstances?
No, Your Honor. In this case, given her criminal record, and she was in and out of jail, and every time she got released, she committed another robbery and kidnapping scheme. Her prior crimes are very similar to this incident. And the judges below expressed the terror that the victims testified to at trial. And there was a gun used. Again, she didn't hurt anybody, but that doesn't negate the lasting psychological effects that she caused her victims to have. So if Your Honors have no further questions, we ask that you affirm.
Thank you.
Thank you.
In other cases, panels of this court have considered this life sentence type reason to reduce a sentence. In People v. Major, that was a 52-year to life sentence reduced to 20 years, and that he was also a persistent violent offender, had a serious record, and that was for a robbery, burglary, attempted assault, and there were actually injuries there. And the reason was because, as our justice system should, and a panel of this court did, think long and hard about what cases warrant someone never seeing outside a prison wall again and dying without their family in prison. And additionally, People v. Mitchell, this court has made clear that an extensive criminal history does not preclude the determination of an excessive sentence. If there are no further questions.
Thank you. Thank you very much. Taraji versus ABM Industry Groups.
May it please the court, Yale Pollock for appellant, your honors. The issue on this appeal is very simple. It's whether a court can accept hearsay as evidence of due diligence for service of process when considering a motion to enlarge the time for a party to serve process. Despite precedent to the contrary, the lower court found that one paragraph in respondent's attorney's affirmation was sufficient to establish due diligence, even though he was not the one who attempted service to have personal knowledge of any attempts made. There were no affidavits from a process server of due diligence or attempts of service, and the lower court happened to find it compelling that there were alleged multiple attempts, and the letter S is used in the court's decision, even though only one attempt is purportedly made by respondent's counsel against someone without personal knowledge of the facts, as again, no affidavit from a process server was submitted on this case. So allowing this case to hold would essentially turn the evidentiary system on its head by allowing hearsay when no such exceptions to hearsay apply in this matter. And courts have held that hearsay is not admissible when considering motions for enlargement.
I have a question. Assuming that there is no statute of limitations issue, let's just assume, right? Why do you want to go through this exercise? Because they'll just recommence the action and then try to serve them again. I mean, it's just kicking the can down the road, right?
Well,
I mean,
again,
I would understand if there's a statute of limitations issue, right, and it's
there
run.
is, yes.
Assuming there is not, let's just say there is not, I mean, then...
It's still accepting hearsay as part of a underlying motion.
My point is, okay, I agree with you, it's hearsay and everything, and that we dismiss it. It's not going to stop them from recommencing and trying to serve your client again, correct? Right?
Correct. But they would have to undergo the effort. Here, they made one attempt in 120 days.
But that doesn't buy your client peace, because that means that if he's sitting in a coffee shop having a cup of coffee, someone can just slap him with a summons and complaint, right? I mean, there's something hanging over his head.
But the courts have required more than just one attempt at service in the 120 days, and
Fair
here,
enough.
there's not even a description of the person who was attempted to be served. There's not even a date on the attempted service.
Wasn't there also something in the record concerning the fact that there, excuse me, a service was attempted on his prior address, but apparently the person refused to open the door, and also that your client had surrendered his, I assume his New York State driver's license?
That's in the it's in the record, but again, it's hearsay from Respondent's Counsel. There's no affidavit from anyone that actually had the door refused to them in order to serve process, and even Respondent's Counsel acknowledges that he's not sure if it was Dita, the appellant, who rejected process, or some other family member.
So
Again,
let me
without a
ask you
date-
this, counsel. What possible prejudice would you suffer by an extension of time to serve?
Well, the statute of limitations would have run on,
Well,
that
now,
was the
no, but
question.
at the time that the motion was made, the statute hadn't run.
yes, it had, Your Honor.
Right, so I wanted to follow up on that, because that was my colleague's question. Is it your position that the statute had not run at that time?
It had run.
I'm sorry, that it had run.
On certain intentional torts, yes, it had.
And what is that based on?
This was from an April incident, and the motion to enlarge, April 2020 incident, and the motion to enlarge wasn't made until July of 2021.
Counsel, wasn't the application for the extension made on July 23rd, 2001, before the expiration of the 120-day period to serve on August 4th?
Yes, it was.
2001.
It was
So
made
then
shortly
what's-
before, which is a consideration that, that in the interest of justice, the courts will look at, as to how far in advance they took to make their application. And here it was done a week or two before, again, after only one attempted service, if that, because again, no affidavit of service is here by a process server. We're relying on hearsay from Respondent's Counsel as to any attempts made within the 120-day period in the first instance.
And so, counsel, also, let me ask you, did you take into account all of the tolls that with the governor's orders during that period of time would have effectuated?
That was not argued
Right, but I'm just saying, so frankly, I think there's no possibility that the statute of limitations had run.
Understood.
So here we have someone who makes an application before the 120 days expires. You haven't said any prejudice, because I think it's pretty clear that the statute of limitations hasn't run, and we have a policy in the state of doing things on the merits.
Understood, Your Honor, but again, hearsay was the basis for the motion.
Thank you.
Okay.
Good afternoon, Your Honors, and may it please the Court. Dan Perrone on behalf of the respondent.
So why couldn't we just get an affidavit attesting to the attempts made at affecting service?
Well, there was an attempt made at service, and we were coming up on the expiration of the 120-day period of time to effectuate service, and we were unable to get an affidavit from the particular process server within that 120-day period. And since our application was based on the interest of justice prong, we wanted to have our motion filed prior to the expiration of the 120-day period of time to effectuate service. And the courts have consistently noted that due diligence in effectuating service is not a requirement of the interest of justice prong of CPLR 306B. The other factors that the courts will look at are whether the expiration of the statute of limitations has come, whether the promptness of the request, meaning whether it was made within the 120-day period of time to effect service, and whether there's any prejudice to the defendant. And here it's undisputed that the respondent requested an extension of time to serve the appellant before expiration of either the 120-day service period or the statute of limitations for any of the claims. And there's been no prejudice whatsoever that it's been identified. In Sutter v. Reyes, the court addressed a very similar situation, and there they noted little, if any, diligence was established by the plaintiff in attempting to get an extension of time to effectuate service. The request for the extension was not prompt, as it is here, yet they still found that the grant of an extension was warranted because there was no prejudice to the defendant, and because he had notice before the statute of limitations had expired. Those same facts are present here. Unless there's any questions from the court, I feel confident resting on my papers, and I won't take up any more of your time.
Thank you very much.
Thank you.
I just want to address the comment made about the Respondents' Counsel being unable to obtain an affidavit of service from the process server. That was nowhere in the record below. That's stated for the first time on this appeal. It should not be considered, and there is no excuse for not providing an affidavit of service whatsoever. We have nothing as to the date of purported service. We have nothing as to who was purportedly, a description as to who was purportedly served or refused service here. And again, only one attempt within the 120-day period, and the case cited, as acknowledged by respondent, is distinguishable because there was notice by the defendant of the lawsuit prior to the 120 days. Notice here did not come until my client appellant received the motion to enlarge in the mail at the address at which they said that he was trying to evade service.
Thank you.
Thank you, Your Honors.
People v. Eric Cruz.
Good afternoon. May it please the Court. Garrett Cardillo, Davis Polk, Pro Bono Counsel, alongside the Office of the Appellate Defender on behalf of Appellant Eric Cruz. After 4 days of deliberations, multiple readbacks of testimony, and nearly 20 notes, the jury in this case deadlocked. And in response, the trial court chose to read the first two paragraphs.
Okay, so that's the first question. They never used the term deadlocked. Their note was, I believe, to the effect that we're at a standstill as to certain issues. How do we proceed? They never said deadlocked. They said they were at a standstill as to certain issues.
Your Honor, the trial court, in reading the note to the jury when he brought them back in, he found that they were deadlocked. He read to them on page 2382 of the trial minutes, "I understand you're unable to reach a verdict." And when, in any event, when he decided to give the Allen charge...
Is that tantamount to the word deadlock, counsel, that you used?
Well, they're unable to reach a verdict, and they needed help how to proceed. Their notes
No, they didn't say, that's not exactly what they said. They said, according to my notes here, it says that they're unable, it says, ladies and gentlemen, I have your note indicating that you have been unable to reach a verdict on what you describe as a couple of charges. So this was a multiple charge, this was multiple counts here, correct? So I don't see how you can say there's a deadlock when there's just only a couple of items that are still left open.
Well, Your Honor, they used the word standstill, so they were at a deadlock, or at least unable to reach a verdict on those charges. But
I think, counsel, the problem is that deadlocked has a specific meaning, and therefore there are specific actions which you would have to take if, in fact, you're a trial judge and you receive a note stating that the jury is deadlocked. Here, the jury stated that they had reached a standstill as to certain charges or certain issues, and they wanted to know how to proceed. So as my colleague stated, what that meant was that apparently they had reached a verdict or a determination as to certain charges, but they had not reached a verdict as to other charges. And I think that's exactly at some point what the judge stated, because he said also something to the effect that, well, I don't want to take a partial verdict at this time. It's too soon to take a partial verdict, something of that nature.
The trial, excuse me.
Go ahead.
The trial court read from the model Allen charge. He
Yes.
clearly understood that he was giving an Allen charge, and this court's cases have consistently required that when courts undertake Allen charge, to give juries Allen charges, they must do so in a balanced way. This charge was not balanced.
Right. So exactly. So why? So what he then did was he gave the Allen charge, but he didn't give the entire Allen charge. He stopped at some point in time. So the question becomes whether at the point that he stopped in the Allen charge, whether that rendered that charge unbalanced and somehow unfair and perhaps coercive.
That's exactly the question, Your Honor, and what this court's cases have held, and what the Court of Appeals has held. In the Allman case on page 807 of that decision, An Allen charge doesn't have to follow the model exactly. It needs to embody, in quote, tenor and substance, the principles of the model charge. The model charge here sets up an instruction whereby the first few paragraphs are coercive in nature, and they're balanced by a paragraph, the fifth paragraph, that reminds jurors that in the face of those urgings to not abandon their judgment in order to reach a verdict. This is not a case where the balancing was bad because the judge departed from the model in different ways. This is a case where there was no balancing at all. And it's precisely what this court in Ali encountered and determined that required, in terms of the instructions, an urging to, if you look at the language here, if you don't reach a verdict, all the weeks of work that you had in hearing this case would have to be thrown out because a new trial would have to be ordered. Most juries reach unanimous verdicts. It's exactly those two instructions in isolation that this court in Ali found to be coercive and required not just any balancing language, but the cautionary note that jurors shouldn't yield any conscientiously held beliefs in order to reach that unanimous verdict.
Right, and the judge stated the reason that he was not giving that additional portion of the charge was because it was obvious that the jury had already reached a verdict as to certain charges, so therefore it was obvious to him that they had not surrendered any beliefs in the case. They were doing what they were supposed to do, what they had been directed to do. However, they were just questioning how to proceed as to the other charges.
Your Honor, we don't know what the jury was thinking, and if we look at the record of the deliberations, there's a clear inference in the record that they were troubled by the evidence as to Mr. Cruz. For example, they asked for a readback of the conspiracy charge, the top count here, twice. So we don't know what they were worried about, but we do know that there's a clear inference in the record that they were struggling with the evidence as to Mr. Cruz. I see my time has expired, and I'll address
Thank you. Yes, you have time on rebuttal.
Thank you.
May it please the court, my name is Patricia Curran and I represent the people on this appeal. The court properly instructed the jurors in response to the note that they had come to a standstill on a couple of charges and needed help on how to proceed. To begin, although defense counsel below opposed the court's giving the charge that it gave, he never raised the specific arguments that he advances now on appeal.
So wouldn't the better practice have been to just, if you're gonna read the Allen charge, read the whole thing?
Respectfully, Your Honor, we disagree.
Why?
The court laid out the reasons why he felt that giving the entire charge, which is what the three defense counsels asked for, was inappropriate here. First, it had been an extremely long trial. There were 14-some days of testimony, multiple witnesses, multiple defendants, numerous intercepted conversations, multiple drug counts, and multiple charges against the three defendants who were charged with this very complicated drug conspiracy.
I understand all that, counsel, but what's inappropriate about reminding the jury that they should not give up their consciously held beliefs to counterbalance the whole advising them that if they didn't reach a verdict, that they would have to submit it to a new jury?
Well, Your Honor, as we mentioned in our brief, the supplemental instruction has to be viewed together with the original instruction. And during that original instruction, the court did tell the jurors that neither of them, or any of them, had to surrender their honest beliefs if they were outvoted or if the time was late.
They did receive that instruction initially?
Initially, during the initial charge, yes. And given the background of this case, even though the jury had been deliberating for 4 days, the court made a very clear and specific record as to exactly why it felt that a shortened Allen charge was appropriate here.
When were they told that they should not abandon their judgment or their individual opinions?
During the initial final charge to the jurors, Your Honor.
I'm sorry, was that during the initial charge you said? Where was it?
When the judge charged the jury initially at the end of the entire case and gave the jury the entire charge about all the charges and the regular general charges, that's when he told them that they did not have to give up their honest belief. He did not use the word conscience, Your Honor, if that's what.
So this is when he was charging as to deliberations and you have to express your opinions with your fellow jurors?
Yes.
That portion of the charge?
He gave a very long, I'm sorry, Your Honor.
No, that portion of the general charge?
Yes, he gave a very long and detailed charge
So to
with
be
regard
clear,
to
had he read the entire Allen charge, this would have been the second time that the jury would have heard about staying with their consciously held beliefs.
Well, that may have been true, but it certainly doesn't mean that the court didn't
No, I'm not implying
properly
anything else.
exercise.
I just wanted to know directly whether, had he done the full Allen charge, this would have been the second time, meaning that they had already heard the instruction once.
Yes and no, Your Honor. The CJI Allen charge has slightly different language than the court used during its final charge to the jury.
And the CGI Allen charge it's a fairly long charge. I mean, I think it's 2 pages or something like that.
Yes, Your Honor, it
So
actually
what
does.
I'm not understanding is, you're going to go through a page and a half, almost 2 pages. Why leave out the last couple of lines? It
No, Your
doesn't,
Honor. The
doesn't
court,
seem to make any sense. You're reading it as it is. I mean, you have to read it as it is. You have to read the 2 pages. Why not just, continue and read the whole thing with the additional couple of lines?
well, the court may have felt that given the fact that the jury was obviously working industriously, this was their 19th or 20th note, and they indicated in the note involved here that they had trouble only with a couple of charges, that such a heavy charge would not have been warranted. And also, I think the court at one point said that he would rather reserve the larger Allen charge, if necessary, somewhere down the line. If there are no other questions about that or the other points involved in the
Counsel,
brief?
yes. With respect to the PowerPoint that was used during the opening statement, would you address that briefly, please?
Certainly, Your Honor. The first thing I want to remind the court is that this court has already agreed in terms of People v. Frankie Santana that it was permissible for the assistant DA to use a PowerPoint during the opening. As you know,
That's true, counsel. I sat on that panel, but what I understand the defendant to be saying in this case is that it's different as to him because he was highlighted somehow as the head of this organization, conspiracy, whatever you want to call it. So what do you say to that?
well, I think the defense is arguing that he was a manager in this particular drug conspiracy. And the people did argue that, but they argued it verbally, and therefore, as you know, the Court of Appeals has found in terms of summation, that if the lawyer can argue something verbally, there's no problem pointing to a visual demonstration of that. So the assistant district attorney certainly was well within his rights to argue that the evidence would show that this defendant was a manager, and indeed it did show that.
But I thought there was a chart where it had a hierarchy of the individuals involved, and the defendant was, like up top. I don't know whether it was lateral or whatever, but he was pretty much up top.
There was a page there were 13 pages in the PowerPoint, and I believe we have sent that to the court. On the top are photographs of 3 defendants, not mugshots, but taken from the Department of Motor Vehicles. This defendant, his brother Osiris Cruz, and a defendant who pled guilty named Denny Guerrero. Below that is Frankie Santana, who was the co-defendant where the court affirmed the judgment several months ago. There is a line going from the Cruz brothers down to Santana, just a black line, and then a black line going from Denny Guerrero horizontally to the Cruz brothers. That is the extent of, I wouldn't call that a chart, but that certainly says no more than what the assistant said and was entitled to
And
say
wasn't
during
that
the
line to show who was calling whom, for what purpose, right? Those lines, as I recall, because I sat on that panel too, I think was consistent with phone calls that were being made in between the various parties.
There were lines indicating dates of drug sales.
Oh, drug sales, right, drug
Is that
sales.
what Your Honor is
right.
referring to? Yes, there was a blue-colored page with
Right.
a line and dates of the, I think, 12 or 13 drug sales involved in the conspiracy. If there are any other questions about that or the jury notes where the defendant is arguing he was absent, I'd be glad to answer them. Seeing none, we rest on our brief. Thank you.
Thank you.
This court's cases have never held that an initial charge to the jury can cleanse an unbalanced Allen charge. And this court in Aponte rejected that exact argument, and it was affirmed on appeal. And it makes no sense in the context of this case. The judge charged the jury in that initial charge on Monday, gave the case to them at noon, roughly around noon, and they deadlocked around 3:55, according to the time on their note, on Thursday. The whole purpose of this court's Allen charge jurisprudence is to avoid the risk that an unbalanced charge will lead a juror to believe that they have no choice but to convince other jurors of their position or surrender. That's why this court in Ali, for example, required that not any balancing language be used, but a reminder that jurors not yield their conscientiously held beliefs in the face of instructions to reach a verdict. It's the balancing that's critical. And with respect to the PowerPoint, Your Honor, it's not only the lines, it's the positioning of Mr. Cruz's picture on the slide. I see my time has expired.
Thank you. And also, counsel, please thank your firm for allowing you did this pro bono.
Yes.
So we appreciate your efforts as well as the efforts of your firm. Thank you very much. Next matter is Williams v. Citigroup. Justice Rodriguez is recused on this matter. Antsy today. Why are you so antsy?
Good afternoon, Your Honors.
Killing me.
May it please the Court, my name is Daniel Hume, representing Plaintiff Appellant Linda Williams. I want to start by saying this appeal is really about whether defendants' respondents met their heavy burden to deny appellant her day in court. They fail at several steps. The first thing the defendants would have had to do is establish a prima facie case, and that can only be established when one looks at the entire record that defendants submitted. We postulate that the record as submitted just by the defendants is rife with its own factual issues. The trial court below described the entire record as rife with factual issues, and she was right. The standard on appeal in New York is of course de novo. The standard below and the standard for summary judgment is whether there are any factual issues left after prima facie case is met. We say that once you get past the prima facie case, even if that could happen, you run into a whole host of contrafactual assertions by the plaintiff, supported by evidence, and you can never get to the point of eliminating those and granting summary judgment. We submit that the trial court erred by accepting the defendant's submissions that you have a preponderance of the evidence standard here, as if this was a trial. But New York law is clear, and frankly, federal law is clear, that it's not a preponderance of the evidence. It's not who's more right. That's weighing the evidence. Only the trial jury should be doing that.
So, counsel,
Yeah.
For me, everything boiled down to one big question. If you're in airlines, would you want to enter into an agreement or a structure, rather, that would allow yourself to be evicted from an airline terminal and relet to a competitor airline? So I guess my question is, when you look at all the issues in the record that are raised, does it all boil down to that simple question? If you were in airlines, would you really want to enter into this kind of structure, or would you say, this is a terrible idea, the risk is too great, ergo, I don't want to touch this, it has nothing to do with conspiracy? Isn't this the analysis that the court made in granting summary judgment?
No, Your Honor. In fact, I mean, first of all, the defendants and the airlines involved, they did do a deal that we talk about, the JFK IAT deal, in which there was a separate entity. There was some aspects of having a separate entity in between the airline itself, in that case Delta, and the financing. Here, there's been no evidence raised. There's been no evidence that the airlines really were concerned about that. There have been suggestions of it, but when we look at the record, there are a lot of issues of fact as to whether that's really true. And in terms of the airline getting evicted...
This was pitched to a number of airlines. So Goldman pitched your client's idea to JetBlue and Delta and American and JPM, pitched the idea to Continental, USA, and Port Authority, and the Port Authority. Isn't it possible that that this wasn't a conspiracy and that the structure collapsed of its own weight, that there was nothing vile going on, nothing going on other than that?
Well,
They said no, and then the financing structure said, we're not touching this. Our people don't, our clients don't want this.
well, that's not how it really unfolded. In fact, various airlines did express interest in the structure, and so did the banks. The defendants all did, starting with Citi.
So, counsel, I'm looking at every single witness who testified about that, and each one of them said that they remember the pitch or something about the pitch, and none of them, not a single one of them, said that they thought that they would do it. All right, so let's assume, because your claim is for tortious interference and from conspiracy, right? Let's assume just for a second that the defendant has made out its burden, that every single witness testified who was supposed to be part of this conspiracy or affected by this conspiracy gave a legitimate reason why it was not interested in it. What facts did you put in opposition to that showing?
Well, I think we put a whole host of facts. I mean, you can go back to our brief at 38.
No, just tell me. I mean, I want to hear.
Well, I could start with, the Port Authority deal, for example. Defendants put in.
The testimony, okay, so what did you put in opposition from the testimony from the Port Authority who said that the structure was never approved and he couldn't recall, although he couldn't recall why. So what did you put in opposition to that?
We put in opposition the testimony and also a
What
memo.
testimony? From whom?
Crystal Mullins' testimony from JPM. She wrote a contemporaneous memo saying that, in fact, the structure was preliminarily approved, and only
But it
later.
didn't get, right, so it eventually didn't get approved.
Only later, after Citi interfered. That's the allegation.
You're telling me that you have an email that says, after Citi interfered, we didn't approve.
No, but we have.
No, of course you don't. The only thing you have is your own client's belief, correct?
No, we don't think so. We have.
Okay, what other facts, what other documents can you show, or testimony from anyone other than your own client?
Well, again, I just cited to JPM's
That they did preliminarily approve it, and then later on they didn't. That's testimony that you're saying raises an issue of fact?
We have circumstantial evidence that Citi spoke to the Port Authority, and then.
What circumstantial evidence?
Well, the conversations are testified to. I don't think that's in dispute. So the question is what.
Yes, but what is the evidence that they spoke and said anything about, you better nix this deal?
We've got, there's evidence throughout, again, cited throughout the brief that Citi, that.
I hear you saying that generally. I'd like you to just give me one or two specific examples of what you think is evidence that raises an issue of fact. Just one or two.
I mean, sure. We've got evidence of first Citi telling, American Airlines, for example, to stay away from the deal. We've got references to the plaintiff as a crazy woman. We're not going to work with her.
You have evidence of Citi telling American Airlines to stay away from the deal? You have evidence of Citi telling American Airlines to stay away from the deal? In what form? Where is that?
These were conversations that happened during and after meetings and things of that nature. That's.
And you also claim that Citicorp somehow leveraged its relationship with Pillsbury, with her firm, in order to terminate her employment.
Yes.
What was that based on?
Well, we've got the testimony of Pillsbury folks who.
Saying that Citicorp told them to, that if they wanted to continue their relationship, they had to terminate her employment?
Yeah, I mean, we've got Citi interfering with that relationship, saying, we're not gonna give you work if again that woman is anywhere near it, things like that.
Okay, I did not see that in the record in terms of those conversations or emails, but thank you. You have time on rebuttal. So, counsel, where in the record is it that there's concrete emails or conversations wherein Citicorp makes this statement to Pillsbury that they're not going to continue working with them or giving them business if this, as your adversary stated, this crazy woman continues to be in your employ?
It's nowhere in the record, Your Honor. And the trial court correctly granted our motion for a summary judgment. I'm speaking on behalf of all respondents here, Your Honor, and may it please the court. The court, applying the New York summary judgment standard, required us to set forward our prima facie case, why we were entitled to judgment as a matter of law. And then once we did that, she put the burden back to plaintiff to come forward with evidence, actual evidence, that there was a material dispute of fact, and they failed to do that. On the prima facie side, just start with the statement of undisputed facts. Paragraph 28 talks about plaintiff and others going to, and then it lists, I think, 6 airlines, 5 port authorities, other entities, financial advisors, to present her structure to the market. The folks she was doing
What I'm
that
interested in, though, this deal that this new investment vehicle that the plaintiff came up with, it just didn't fit the airline industry's model of how they were going to get funding, right? Because the way it was revolutionary. Clearly, it was revolutionary because it was going from, I guess, how they structured the deals versus how much time at the gates versus how much, what their credit ratings were for that, and then versus her revolutionary way was just based on, I guess, supply and demand type of thing. And the airline, I'm just driving down to the point where the airlines are saying no, because if we went her way, we could get evicted from our gates at a minute's notice, and we're stuck at that point. We don't have anywhere to go.
Exactly, exactly. So we're handing over the keys to this special purpose vehicle that will kick us out, whereas if we are in the state of nature, the way things are now, and we have problems when we go bankrupt, we can decide. We can decide to reject or assume the executory contract.
Yeah, I'm just looking at the deal itself, the structure of the deal itself. I mean, you know, putting aside everything about whether or not there's interference and whether or not there's, you know, tortious interference and whether there's a breach or whatever, the deal itself didn't make any sense. And their experts kind of didn't really talk about that, right?
They didn't. They just constantly assumed the conclusion. They assumed, I assume, says the plaintiff's expert, we could, in the right circumstances, we can get an investment grade rating. And then I assume, says the other expert, that if you get an investment grade rating.
We know how volatile the airline industry is, right?
Correct.
Okay.
Well, they said they could have achieved investment grade credit ratings if the threshold conditions of a strong airport and strong market were met.
Right. It's the classic economists assume the can opener kind of line. And the important thing is, I mean, and that just puts her still several steps away from having any claim here. So number one, it made perfect sense why the airlines wouldn't go for this structure. And Ms. Williams acknowledges they were the deciders, not my clients. They were the deciders. Number two, the testimony is uniform for all these folks. American Airlines, they're not a widow or orphan. They have a finance department. They reviewed the structure, and they decided that they weren't going to go with it. And it was presented to them several times, including thanks to the efforts of Goldman Sachs and JP Morgan, who were working with plaintiffs, to do that. And then third, they're not taking it, apart from making perfect economic sense. There is no evidence in this record that they're not using the structure was the result of any concerted effort by any of the defendants. And that's, of course, the essential element
and
of
in
any
fact,
antitrust claim.
you know, and you hit a point. And in fact, nobody ever even used this concept, right? It wasn't as if you'd have a better argument if someone actually used in some form, a hybrid form of what the plaintiff was proposing. It wasn't done at all.
Correct. Correct. And they say at JFK IAT there was a, quote, weaker form of this structure. I'm not sure how that gets them anywhere. That structure was in place from the 90s, and then when it was re-upped by JFK IAT in 2010, they just took the structure forward. So that doesn't support any conspiracy to boycott her at all. So there was, on our side of the case, this evidence of independent conduct by the airlines, no concerted interference from any defendant. You have no parallel conduct. And so that should be the end of it. But then plus you also didn't have any of the so-called plus factors. It's a very interesting case we're talking about. This plaintiff is claiming that there's a conspiracy when there's not one email, there's not one bit of testimony, that any of these defendants even spoke to each other about the plaintiff and her structure. So how they could have come to a concerted scheme is really beyond the realm of speculation. So for all those reasons, the court found we had made our prima facie case, and then carefully looked at the evidence that they marshaled, and they threw a lot at the wall. And I have to say, in their brief to this court, again and again, you find a cite to some unidentified document. They're often citing their brief below. That's not evidence, their brief below. And then the evidence that they did, quote unquote, claim never went to raising a material fact that there was collusion here among any of the defendants. And then as to the tortious interference claim, since the Donnelly Act claim failed, the court below correctly found that there was no wrongful means to support the tortious interference claims that she was alleging. She tried to recast it as well. The independent tort was fraud. That was something that was only raised in opposition to summary judgment. And this court's decision in Mitchell and other cases is crystal clear. You can't stand back an alternative theory of liability and save it to try to oppose summary judgment. So the court properly rejected the tortious interference claims that were asserted against J.P. Morgan and Citi. And in any event, even if you looked at them in the merits, they failed because, again, there's no dispute of facts as to why she didn't have these relationships with the American Airlines, with B of A. Every person from those entities with whom we allegedly tortiously interfered testified in their deposition, and there were 32 depositions in this case, that they made their own individual assessment. They were not harassed, they were not coerced, they were not threatened by any of the defendants, either alone or working together. So the client had her the plaintiff had her full day, 32 depositions, a lot of discovery. The facts were just not there, and the court was correct in granting summary judgment. Unless your honors have any questions, I'll sit down.
Thank you.
Thank you.
Your Honor, 2 quick points on the, returning to the, the Pillsbury question that I think ended my first time slot. I mean, there certainly was evidence, and we've got Schumacher from Pillsbury testifying that after Citi expressed to him Pillsbury's position on his approved counsel list could be jeopardized by plaintiff's patent application. We've got other testimony that the firm's managing board decided plaintiff should resign over the patent issue. There's a lot, there is certainly evidence to contravene the, frankly, self-serving.
But I mean, counsel, aren't you allowed to take care of your own business? It's not tortious interference if you say, if you hold that patent, that's going to hurt us, and therefore, why should we hire a law firm that does that? That's a completely legitimate business reason not to give your business to a law firm where someone holds a patent that's going to hurt you economically. That's pretty straightforward, isn't it?
Well, we certainly don't agree. We think that it's not. We think it is, wrongful means to be.
And in fact, didn't they all testify that that wasn't the reason why? I mean, every single one of them, or there was more than one person who testified that, right?
There's really no other reason put forward as to why.
Yeah, see, that's what I get from your argument. It seems to be the argument that this was such a great plan. It was such a great structure plan, and it was so cutting edge that the fact that it was rejected means that there must have been something underlying all of these rejections, because it was so great that these airlines should have jumped at it, and the fact that they didn't do so means that there was some kind of collusion or some type of underlying reason for it, not because the plan just didn't work for them.
Well, no, it's certainly not just that. I mean, although that does say something. What we're saying is,
Could we just say that it was a lousy plan from their perspective?
But that's not what they said then. Now, when defendants are litigating this case, they're coming up with pretexts like loss of control. But there isn't evidence at the time that this was a concern. Even Citi. I mean, Citi raised that concern in the very first meeting, and then by the end of the meeting, with Pillsbury's advice on the issue, they realized that wasn't a concern. So what you have now is litigation with a bunch of pretexts and excuses, but at the time, those were not mentioned. There's no evidence of it, and we think at least there are factual issues about those, about those supposed pretexts that are being raised now. We think it's hindsight. So yes, you can look at the structure and say it makes sense or it doesn't make sense. The question really is, what were the participants thinking at the time? And we think there are a lot of factual issues on those subjects.
Thank you. Thank you both. New York Marine and General versus Westco Insurance.
Good afternoon, Your Honors, and may it please the Court. Matt Ronan for the defendants, Westco, Technology, and AmTrust. This was a two-part motion that the Court denied of ours. I'll start with the motion to dismiss. It's really a partial motion to dismiss, only on behalf of AmTrust. The Court below should have granted AmTrust's motion to dismiss because AmTrust is not a party to any of the policies here. There's no fiduciary relationship.
AmTrust's obligations, correct me if I'm wrong, runs through Westco and TIC, right? They're the administrator for those two primaries.
That's correct. AmTrust is the claims administrator for both Westco and Technology, or TIC. New York Marine, who is the excess carrier with respect.
But there's no relationship. AmTrust is not separately in any way, based on this record, I see it has any obligations, contractual or otherwise, to the excess carrier, right?
That's correct. There's no relationship at all.
And isn't there a possibility that those two interests would be adverse to each other, correct?
The interest of AmTrust and New York Marine?
The primary and the
excess.
The excess, right?
Sure, there's certainly a possibility.
So you can't have a fiduciary duty to two different entities who might have conflicting interests in a case, correct?
Correct.
Right? So it doesn't make any, right, okay.
If there are no other questions on that issue, I'll jump to the venue one. The venue one is perhaps a little more interesting because it deals with some new language in the CPLR from 2017 where it says we're going to go beyond the counties where everybody resides, and we'll say if it's a county where a substantial portion of the events or emissions giving rise to the claim occurred, we'll allow venue there. This is not an issue that's been reached by the Appellate Division in the insurance coverage context, but I think quite simply.
But let's start with what you put in on your burden. What did you put up for your burden to show that the plaintiff's choice was incorrect?
Sure. So it's not the defendant's burden to show.
Yeah, sure it is. If you want to change a venue, right? You have a burden. Anybody who moves has a burden. What did you put up on your burden to show that the plaintiff's choice was incorrect?
Sure. So what we put up as evidence was the point to the plaintiff's complaint, which is really all there is.
Did you put in any affidavits?
No, and per Vereen, which is an appellate court decision, we don't have to.
So you're saying but your argument is we didn't make any of the decisions about coverage in Bronx County, correct? That's your argument.
Correct, or more.
So did you put in any affidavits from anyone who would say to show that that was true?
Well, I would say more particularly the argument is there are no allegations that the wrongdoings of the defendants took place.
Plaintiff says they were. That's what the plaintiff says, right? Again, it's your burden of proof on the motion. So you say we didn't do anything in those counties other than the attorney who has no personal knowledge saying that. Did you put in any affidavits from any of the actual claims adjusters or anyone from AmTrust or anyone else saying none of these decisions were made in Bronx County?
No, Your Honor.
So nothing was put in, no facts were submitted, just an attorney affirmation and arguments at law, correct?
That's correct. Because
and have you ever seen us have you ever seen us say that's enough on this kind of a motion for a move-in's burden?
Well, I mean, per the Vereen decision, which is an appellate court decision, the obligation was to point to the complaint, point to the however many pages of the complaint there were, and there are a lot, and say, look, court, none of these allegations in this complaint allege that these acts by the defendants took place in Bronx County.
They say in their complaint that there was bad faith, that all these decisions were made, and they got essentially that they wound up paying money that they shouldn't have had to pay. That's in the complaint. It's not, that's what they say in the complaint. That's in fact what this complaint is based on, right?
Of course, those are the
So,
allegations.
and you didn't put in anything in opposition to that to say none of these decisions took place in Bronx County. That's my problem. You can see where I'm going with this, right?
Correct, and I would just take the legal argument that it was.
Yeah, but I mean, you have to say, you can say whatever you want in your brief. You have to have a factual backup for it, right?
I disagree, but I'm not going to convince you.
So, counsel, I want to take issue with something different. So there is no affidavit from any of the non-party witnesses that were expected to be called, but in the reply brief, in your reply brief on page 12, you said the following: having to leave work in downtown Manhattan during the workday to travel to the Bronx is far more inconvenient than taking a short walk to court in Manhattan. Really? I mean, you know, this is a panel that is comprised of Manhattan-based and Bronx-based judges, and you're saying that it is really difficult to take a train or a cab, or some people bike from Manhattan to the Bronx, and that's a basis to change venue.
Sure, so just, my time's up, so two very, very quick points. One
It
is
doesn't
that's,
let you off the hook on this one,
and I could answer them later, but one is that's a separate issue from the motion as of right. It's a different part of the CPLR, you know, convenience to the witnesses. The other is the appellate division has decided before that a neighboring county is inconvenient. Thank you, Your Honors.
May it please the court. William Stewart here on behalf of New York Marine. I'm going to take the court's lead and spend most of my time spending on the AmTrust issue. But I do want to just make one quick comment on venue, and that's that even if there had been affidavits, this is just at its core a Bronx-centric matter. This is a case about two cases. Those cases were tried in Bronx County. AmTrust had claims adjusters in the court in Bronx County, fielding offers in Bronx County, doing reports with regard to juries and motions and judge actions. This is a case involving policies that were issued to entities in Bronx County with underlying injuries in Bronx County. This is a Bronx County case, and it's is and should have been filed in Bronx County. With regard to the AmTrust issue, New York law permits an excess carrier to bring, among other claims, in a wrongful refusal to settle case, a fiduciary duty, a breach of fiduciary duty case.
Against the claims adjuster of the that's a general statement. There's never been a case where, let me start with this. Do you have your own claims adjuster? Does the plaintiff have its own claims adjuster?
Does ProSite use one of its entity arms to do claims? I don't know if it does, but it's certainly
I'm
commonplace.
sure it does. I've never seen an insurance company that doesn't.
I follow your point.
Right? So if there's a fiduciary duty between AmTrust and its primary obligors, right? Or the primary insurance companies.
Yes.
And it says to the primary insurance companies, I don't think this case, I think you will not reach your limit, and I encourage you to fight this case. But, on the other hand, if you settle it for the limits of your policy, then the excess has no obligation to pay. You cannot have competing fiduciary duties. And clearly, that's what you're seeking to impose here.
Well, but you're assuming those communications took place. What I suggest is the true fact pattern
I'm just assuming in any case, you cannot have a fiduciary duty to someone who is in conflict with the person that you have a contractual obligation and maybe a fiduciary obligation to. There's no possibility of those two things coexisting. And you haven't alleged a single fact that would support such an obligation. What's your confidential relationship with AmTrust?
So I am suggesting to this court that AmTrust took the place of TIC and Westco with regard to those
That
duties.
was your choice, right? You have your own, you have your own adjuster. You could have sent your adjuster. The excess carrier has as many adjusters as the primary carrier. If you choose to allow the primary carrier to do that, that's your choice. But that doesn't raise a confidential or fiduciary. I mean, being a fiduciary is a very, very onerous thing. So the fact that you allow the primary to do all of the negotiations doesn't create on the primary's claims adjuster a fiduciary duty to you, does it?
Well, I think New York law creates that duty.
I've never seen a case. Let me say this. You didn't support that argument with a single case. You supported it with a general court of appeals case that says you don't necessarily need a contractual relationship to prove fiduciary duty, right?
We cited the Hartford accident case that stands for the proposition that whoever is handling the claim owes a fiduciary duty to the excess carrier. That's the language in that First Department case.
I don't think that's what it says, but okay. All right.
I understand. It's a critical point of our argument, so I read it a couple times this afternoon.
I think I've read it a few times myself.
Okay.
You know, counsel, what troubles me is, what concerns me is if I agree with your analysis, that would open up every single claims administrator whose obligation runs to the primary only to lawsuits from excess carriers for breach of fiduciary duty. So then they're going to take a position, well, who do we owe the duty to? The primaries who we have a relationship with, or the excess? Because at that point, there's going to be a conflict. I can't split myself down the middle when I'm negotiating a settlement. I got to know who I'm negotiating for.
Can I just respond to that very quickly?
Please.
The flip side to that is TIC and Westco didn't do anything. They just said, AmTrust is handling everything. So now I'm in litigation with TIC and Westco, and they're just saying, well, we didn't do anything. We just hired somebody else to do it. And I think based upon the Hartford case, whoever actually handles the claim on behalf of the insured is who owes that duty to the
No. They're your agent. They're the agent of the person who you might argue that the underlying insurance company owes your insurance company a duty, but there's no separate duty. The claims adjuster is an agent of the insurance company. That would have been a better argument in my view. You sue the insurance company for breach of fiduciary duty, right? And how are they breaching it? Because their agent, the claims adjuster, isn't representing your interests. That's a different thing. You didn't say that.
I understand, and I just would direct the court to that decision, and I'll let it lie. Thank you so much.
Thank you.
Your Honors, I'm happy to answer any questions you have. Otherwise, I'll yield to everybody that comes next.
Thank you very much. Thank you all. Continental Casualty versus KB Insurance.
Good afternoon, Your Honors. May it please the court. David Shire for Respondent Continental Casualty. I will be very brief. I just want to highlight one issue that appellant in reply simply chose not to respond to the fact that a significant portion of the costs in dispute arise from before the date that Continental could have potentially owed a duty to defend. And other than that, unless Your Honors have any questions, I'll rest on my briefs.
Any questions? No. Thank you very much, Counselor.
Thank you, Your Honors.
Small versus the City of New York, which Justice Oring is recused on.
Good afternoon, Your Honors. May it please the Court, Soledad Rubert for the appellant respondents. Your Honor, after the submission of the briefs, I believe that a lot of the issues that were originally raised are no longer before the court. There are three issues that are before the court for its consideration, and I'd like to take them separately. The first one is whether the Supreme Court erred in submitting a separate charge on fear of impending death, and also giving a line for the jury to award damages for that. The first argument we have is that the objection to that was not preserved. It was not in the record. Now, subsequently, during the motion to set aside the verdict, one of the attorneys said that this had been brought up in the, I think in the chambers during a conference, and that they had objected, but when, at page 1389, when the court said we had discussions up in chambers, but now we're going to put them on the record, I want to make sure that they're memorialized for the record, no objections to those charges were made. So it is our position that any objection to that separate charge and to a separate question for the jury to award damages was waived and should not be considered by this court. And in any event, even if it was properly objected, which it was not, the court was correct in charging that. This court, in a case of the 91 Street Crane case, actually did affirm a award for the pain and suffering and a separate award for fear of impending death. Now, defendants argue that the awards for fear of impending death are only applicable in cases where there's an accident with traumatic injuries that suddenly happen and cannot be charged in a medical malpractice case. There is no case law that says that. And to the contrary, several of the cases, including one that was cited by the defendants, I think it's called Mancuso, was precisely a case where the court said that fear of impending death can apply in a medical malpractice case. And in this case, there is no doubt that there was evidence to that effect. For 2 days prior to his death, he was told that he had to have a transplant, and his mother, he was saying, "Mommy, I'm going to die," and there is absolute evidence that it was. So even if they had objected to it, the court was correct in charging it. Now, with respect, the next issue is really the propriety of the reduction of each of the damages. And it is our position, Your Honors, that while this court and the trial court have not only the duty but the power to reduce or increase verdicts, it has to also be tempered by the fact that the jurors are the triers of the facts. It is our position that a reduction of a $22 million verdict to a $4.5 million verdict is excessive, and it doesn't reflect what would be reasonably compensation under the facts of this case.
So we would have to find that the trial judge abused, in this case, his discretion, by reducing those awards.
To that extent, yes.
Right. And so then, do we not also look at similar cases?
We do, but as the...
And so when you look at similar cases, is the reduction, which was done by that trial judge, is it so far off the mark as to what those other cases?
We believe it is, and we also believe, Your Honor, that as the judge himself wrote in the decision, this was a very difficult case to have to compare to other cases because of it was a very different kind of a case. We have here a young man, 22 years old, who is put in solitary confinement for 55 days and is left pretty much to die.
But he stated or complained of the injuries. It looks like 3 days. It looks there is a 3-day period, right, where there was actually, he commented to his mother or something of that nature that he wasn't feeling well.
Well, he did, but there was also medical testimony from not only our experts, but the defendant's experts, that he had, in fact, that the damage that he had when he got out of the solitary could not have happened in 3 days or 2 days. It was damages that were ongoing. It had to have happened at least 3 weeks, and the reason that nobody knew is because they were not doing what they were supposed to be doing. Now, I see that I ran out of time, but we
Yeah,
also...
but you have time on rebuttal. Thank you.
Okay.
You can address it on rebuttal.
Okay, thank you.
Yes.
Good afternoon, Your Honors. May it please the Court. Jonathan Poplow for Respondents, Cross Appellants. I wanted to pick up where you left off with Appellants Counsel, and that is that the trial court did providently exercise its discretion in reducing the total damages award to $4.5 million. I think the court doesn't really need to look any further than its own decision in 2019 in Murphy-Claggett, which was an asbestos mesothelioma case, and we deal with it extensively in our brief, but just to sort of recap, as this court noted in its decision, the decedent there suffered, severe and crippling symptoms and tremendous physical and emotional pain and suffering, which included fear of impending death over a much longer period of time than that was present here. And I think as we lay out in the brief, the symptoms were certainly as severe, or if not, I think quite arguably more severe.
So that reduction was, the jury verdict on that was, you talk pain and suffering, the jury verdict on that was $8 million, and that was reduced to 2.75.
The jury verdict, in our case, yes. And in the case I'm referencing, the jury verdict was 25, and this court it was initially reduced by the trial court, then this court further reduced it to 4.
Okay, so now, fear of impending death, on that one, I mean, that's a substantial reduction. The jury verdict on that, and we're talking about this case, was $8 million. That was reduced to $500,000.
It was, and I think I can address why it shouldn't have been submitted at all, but let's say you take that and you add it to the 2.75, so that's the total component of for the malpractice, for the non-wrongful death damages. So that's 3.25 in a situation where, the pain and suffering was from a much shorter duration and arguably not as severe compared to $4 million in Murphy-Claggett. So I think that shows the reasonableness of the overall reduction.
Counsel, can you address, too, why you think that there shouldn't be a separate component for fear of impending death?
Because having it as a separate line item on the verdict sheet impermissibly allowed the jury to essentially compensate twice for the same injury.
How is that the same injury, counsel?
Because the emotional distress that the decedent suffered is properly a component of his pain and suffering. But the line of cases that they're relying on here is the fear of impending death originally arose, and it's also called, in this court's cases as well, pre-impact terror, in a situation where there is a sudden physical injury. And it's designed to compensate for the fear that the decedent experienced prior to the injury, not for the pain and suffering after the injury. So here they were compensated twice for whatever sort of physical and emotional suffering he had after the injury. The Crane case that my emissary spoke of did allow both types of recovery, but there was a recovery for the fear as the crane operator plummeted to the ground, and then also for the conscious pain and suffering after the impact, which lasted, I think the decedent survived.
Is there any dichotomy that's applicable because part of the pain and suffering occurred while he was in solitary confinement, where the protocols for TB management weren't followed, as opposed to what this inmate experienced after he was sent to the Prisoners' Health Services, then to Elmhurst, then to Mount Sinai, because the necrosis had spread. Is there a dichotomy between his pain and suffering while in solitary and then all the emergency treatment and the realization that his body was failing?
No, I think it's unlike, there's not a demarcation, it's a continuum. I think he first complained of symptoms on a phone call with his mother in early May, and then he was released from solitary towards the end of the month, and then I believe his date of his death was June 1st. So there was a deterioration over a period of time. There wasn't, the quintessential cases here are car crashes and whatnot, where there is a particular physical impact. And these damages, to the extent you're going to have them as a separate category of damages, are designed to compensate for the terror and fear you experience leading up to that impact. There's no question that fear of impending death can be properly a component of the conscious pain and suffering. And that's why I'm saying if you look at these
Did you object to the charge?
We objected to the inclusion of it as a separate item on the verdict sheet at the off-the-record charge conference.
Was that preserved in any way when the judge had any objections?
The judge, there's another point that's cited in our brief where the judge says, are there any objections to the verdict sheet other than those lodged at the charge conference? So I think the trial judge is recognizing the fact that there were at an off-the-record conference, there were objections lodged. And I think it is notable that in the post-trial motions, the trial court, who is aware of what objections were and weren't lodged at during the charge conference in chambers, did not address the preservation argument and just dealt with the issue on the merits.
Thank you.
Your Honors, I briefly want to address the last portion, which is our appeal of the dismissal of the civil rights claim at the end of the presentation of the evidence. Defendants concede that there are circumstances under which one violation is enough to have the city be responsible, and particularly where there is obvious that not training people in a particular area will cause them to violate someone's civil rights. That is enough for a civil rights violation. Now, in this case, the evidence showed that there were minimum standards that required the health and hospitals, or I should say the Rikers Island, or the physicians, the people that were taking care of the people, to have a written protocol for continuing education and for the training of people in IH therapy.
So, Counsel, I just wanted to back up for 1 second. Did the trial judge actually make a decision as to your motion?
He did. He denied it. He granted the defendant's motion.
And is there something in writing, or was it so ordered, or something of that nature?
No, it's on the record. He said that it's dismissed and he didn't charge it, and that was the end of it. It was during the trial, at the end of the presentation of evidence.
Okay, so, but do we have anything in writing? Was it so ordered, or any order presented so that we have an appealable order?
I don't believe so. I think that it was because it was done orally at the end of the trial, and we moved. I don't believe we moved.
No, that's what I'm going to ask you. Did you do a post-judgment motion on that issue?
Well, we did.
And did he decide that?
He decided it right
an
at the end of
appeal.
the presentation of evidence.
No. You obviously did somebody did a JNW motion, correct?
Correct.
So in that motion, did you say, and by the way, you should not have dismissed?
Yes. Yes.
You did.
Yes.
And that resulted in a decision.
Correct.
A written decision.
Yes.
Where he reduced.
Right.
And he denied the motion there.
Correct.
So that's the appealable order you're talking about?
Correct.
Okay, good.
Thank you very much.
Counsel, if you wanted to talk about the reduction, I had cut you off. If you wanted to deal with the $8 million to the $500,000.
Yes, Your Honor. I think that if you look at the decision in the Crane case, there was a 12-second fear of impending death.
Yeah, I'm a little familiar with that case, but I don't think that it's really applicable in this instance. I mean, as your adversary mentioned, there was a lot, the facts were significantly different in terms of the crane operator noting his impending death. I mean, there was a lot there are a lot of facts which I think are distinguishable from this case.
And I think that what this court affirmed, which was a 2.5 for one defendant, one plaintiff, and $2 million for the other, is certainly not what's correct here. But I think that the reduction to $500,000 is excessive and should be changed so that it's at least $1 million or a little more.
Thank you.
Thank you. Have a good afternoon.
You too, thank you.
Your Honors, to return to the...
Everybody forgot you had rebuttal.
To return to the procedural point you raised, on the Section 1983 claim, defendants made a oral motion for a directed verdict. There may also have been written papers as well, but it was made at the close of evidence, and it was granted on the record. It's in the trial transcript. To my knowledge, there is not any reduction of that to a so ordered or a decision. The post-trial motions were made by defendants for a new trial or in the alternate for a reduction. I do not believe there was any cross motion about the denial.
Plaintiffs just said that they moved on the 1983 claim. Is that not correct?
That post-trial, that is not my understanding.
Okay.
So I'm sort of struggling to kind of look at the decision on the post-trial motion.
Really, because if they didn't move on it, then it's waived, and they can't bring it up on appeal, right?
Yes, I mean, that's correct. You have to have an appealable order, a decision. And on the merits of it, the Prison Health Services and the department had a written protocol on the treatment and administration of INH therapy, which is at issue here. Liver toxicity, which is what is the reaction that the decedent had that ultimately led to his death, is a pretty rare side effect of that, especially it's exceedingly rare in someone his age. So,
But I thought that the evidence was that they didn't even follow those protocols, because I thought that he was supposed to have periodic checkups or examinations to determine what was going on.
That's correct. He was supposed to have monthly examinations,
Right.
and the evidence showed that he did not. That cannot support Section 1983 Monell liability, because that would essentially just be responding ad superior then, that it wasn't followed in this case, and that the law is very clear on that that's not sufficient. They're trying to proceed on a single incident failure to train theory, which is exceedingly high burden to do that. I mean, the Supreme Court, U.S. Supreme Court has basically said a 1983 case to do that. I'm not sure there's actually even really they just listed it as a hypothetical. They said, if you have a situation where this is the first time that something occurs, which is the case here, there was no notice or reason to believe that it has to be, it's an extraordinarily high burden in those circumstances. And the example they gave was when you sort of, you knew that you gave police officers firearms and you knew that they would have to, as part of their job, apprehend fleeing felons, and you gave them no training whatsoever. Here, there were written protocols on how to do this, and if the protocols weren't followed in this particular instance, that's very different than not having protocols or not having training.
Thank you. Thank you both. Board of Managers, Franklin Place versus New York City Fire Department. Please.
You kept wanting to leave, and then now you want to come back? It's killing me. Yeah, so no more.
Good afternoon.
Good afternoon. I've been on so many panels regarding this condominium that at times I feel like I live there, because we've had so many issues with this condominium and that street. But please continue.
Yes, Your Honor, I didn't have the pleasure of being before you on any of those, and so I don't think this case is related, but we cited actually one of those cases in our reply brief on
It's
what I
the
think is
same little strip of land that we're talking about, right? Between Broadway the same little alleyway between Broadway and Church Street. That has not changed, correct?
Between White Street and Franklin Street.
Yeah.
Same alley, that's right.
Same alley, the
and-
same narrow alleyway.
It hasn't gotten any
It
wider.
hasn't gotten any wider. We have no signs up, which was before. The cars still cannot pull out of the parking lot. If there's a truck unloading furniture, they can't get around.
They could
have
back
to
up,
wait.
though.
Yeah.
They could back it out,
They
right?
can back it out, but they don't want to back it out.
That's right.
I'm sorry, continue.
What happens when you have a panel that's been sitting on this one strip of land for a long time?
Well, I see I can maybe skip some of the facts. May it
boy,
please-
yeah.
Please do.
May it please the court, Stephen Orell for the petitioner's appellants in this case. What I'd like to do is get right to what I think are the two critical points argued by the respondents below and on which the trial court relied. And they're kind of the flip side of the same point. The city argued that there's no positive obligation, and those are words from the mandamus cases, no positive obligation in the fire code on the fire department to ever.
But you're asking us to agree with you and direct. It's a mandamus application that you're asking us to compel the fire department to make that into a fire. What's it called? Fire access lane?
Fire apparatus access.
Fire
road.
apparatus lane, so it's that nobody can be on in that alleyway, right?
Well, we asked them to regulate it as a fire apparatus access
Well,
lane.
when you say regulate, it means that nobody can be there.
That's what we would want, but I'd like to address the issue that the court below raised, which will have to be discretion involved in making that determination because of all the requirements that are put into the fire code for things that a fire apparatus access road should have. A grade, surface, load-bearing capacity, width, turning radius, and all of
Let me
these
ask you a
things.
question. Did they make a determination yet?
They made a preliminary determination.
Okay, so when they make a final determination, you can challenge that in Article 78, can't you?
Well, I suppose we could, yes. And
Well, I mean, but right now, if you're saying there's a preliminary determination, which I gather is not favorable to you, right?
actually, it was. Captain Malloy wrote
Okay.
his letter, and I think it was Exhibit G to the petition,
Right.
that the fire department has made a preliminary determination that Franklin Place is a fire apparatus access road, and we intend to stage firefighting operations from the alley. But
But
we
you have to go a little further, counsel, so I'm new to this. I'm new to this, but.
You're very lucky.
But the letter said more, didn't it? November 29th, 2019, it said that there was a concern with respect to the underground vaults below the roadway.
That's right.
And that the ability of the vaults to handle heavy fire apparatus had to be addressed. Your engineer was the only person to make such a determination, and that person found that the load-bearing capability of the vaults was adequate, but nobody else stepped up to the plate. So how does that factor into your analysis of the import of the November 29th
Yeah,
letter?
let me back up a little
November
bit.
2019 letter.
Excuse me. Let me answer your question about the engineering report. The one that's in the record is from our engineer, and he only was able to examine our vaults.
Yes, we agree.
Right. And he found those were adequate. And Captain Malloy said he wanted to look at the other vaults, and we hadn't had a chance to do that by the time this Article 78 was decided. Our position was that the condition of the vaults should be a subsidiary matter for the fire department to address once it was determined that the road is an apparatus access road. If the vaults needed to be repaired or supplemented in some way, that is something that...
Aren't you imposing your methodology upon the fire department? Doesn't the fire department take more into consideration, such as the diameter, the width, and the width of the street?
Those are things that are within their discretion, although when I briefed it in this court on the Klosterman issue, which I see I'll address this one point, that things which can be, the agency can be told to do as opposed to the means by which they do it. In that case, it was, should they be preparing written service plans for institutionalized patients who were being discharged, exactly what those plans should say, possibly was something that they would have discretion as to do. In this case, I see my time has run out, so I'll address the remainder of your question on rebuttal.
Yes, thank you.
Thank you, Your Honor.
Ms. Kelsey, you represent the city?
Yes, sorry.
Okay.
May it please the court, Antonella Carlin for the city, and I'll just be pretty brief, but I think.
So what I did not understand, there was a preliminary determination that it did, that it was a fire apparatus service road or whatever. So now, why are we here? Has there not been a final determination?
Well, so the preliminary determination was made, but there was concern about the vaults underneath, and I think other things maybe have come to light. But so the fire department asked if they could examine the vaults underneath to make sure, I think reasonably, that they could support the weight, the road could support the weight of a fire truck. And depending on what those studies showed, there would be a final determination, right? And
we're just waiting for a final
unclear to-
determination. I mean, we're waiting, the process is, of my understanding is that there's really nothing to litigate at this point to even for us to tell the fire department to go do this, because I'm not a firefighter, I don't know anything about vaults, but until a final determination is made, and if it doesn't satisfy any of the parties, they can Article 78 that, right?
I agree, and it's unclear to me
So what
why
is
we're
taking
here.
so long for the determination?
Oh, sorry. So it was the petitioner's engineer was given access to the vault and has done the study, and that's all done. I think, has taken some time for them to send the report to the fire department, and I got it before the fire department did, but that's not in the record. So
But I thought that was in 2019.
Right.
So, yes, and then instead of waiting for their engineer to do the study, they just came and went to court and demanded that we designate it a fire access road for, and it doesn't make a whole lot of sense to me why we're here.
So counsel, according to the record, as of December 19th, 2020, the other buildings didn't allow access to?
That's, I mean, I don't know about that, but the engineer has done the studies, and he's been given access, and this, I mean, it's all quite clear.
So what is the procedure now? Their engineers do the study, they submit the study to the city, to the fire department, and then the fire department, don't they have their own engineers who would take a look at the vaults to make a determination?
Yeah, and I think probably other things would go on too, but the point is that I guess, I don't know if they thought maybe the vaults aren't good elsewhere. They had this suspicion.
No, but
and
you
they came
haven't
to
done
court, but-
anything the fire department hasn't done anything for 2 years.
No, that's not true.
No?
So the
What have
fire
you
department, they gave us the study just recently.
Oh, okay, I'm sorry. I
And-
thought the study was done in 2019.
They did the study for only their vault, the whole road, right? So they were granted access to the other vaults. Their engineer did the study and just recently gave it to me, and I have passed it along to the fire department.
Right, because initially there was a not denial of access to the other vaults that they were trying to get to.
Yes, and then the fire
From the
department.
other buildings,
The
correct.
fire department told the other building owners.
Let 'em in.
To give them access, and
Right.
they did, and the studies were done by their engineer. And so it just is,
All right, so you just gotta wait and see.
I mean, and if a road can't support the weight of a fire truck, we're not going to use that road to respond to emergencies, and I
You can
think.
see the lawsuit coming out of there when a fire
Why
truck
would you
just
want to use
goes
this
into the
road
vault.
as a fire access? I don't understand why you'd even want to use this road. I mean, as a practical matter, I understand why they want to do it, but as a practical matter, why would the fire department want to use it as a fire access?
I would say that we wouldn't. Ideally, we would want to use Broadway, but they have made it, they've changed the entranceway so that the frontage space is now on
Franklin Place.
So they just want us to, I think. Yeah, but if the fire truck can't get onto the road, or the road can't support the weight of the fire truck, it doesn't really matter.
And what's the significance of a fire, what is it called, a fire apparatus or whatever? road?
Access road?
Access road. What's the significance of that?
So in rare circumstances where a building doesn't have, can't be accessed by a public road, the building owner has the obligation to ensure that the fire department can access it in case of an emergency, and they have to create a road or.
Let's cut right to the chase. The bottom line is nothing can be parked on that alleyway. It's got to be clear all the time.
If,
right?
Oh, sorry, yes, if we
That's
were
it.
to use it and
Right.
then you could get.
You can't even
out of the
stand,
garage.
it's a like complete no standing. You cannot be anywhere, there's nothing on that alleyway.
Yes.
Because it's
Right.
designated
And from
as
the fire department's perspective, this is so that the fire trucks, in the event of a fire, they would have access, clear access to those buildings.
'Cause it's very, very narrow.
Right, okay, thank you.
Thanks.
May it please the court, Avram Turkel for EMFT LLC. We are one of the neighbors on the south east corner of the alleyway. To answer your Honor's question, they want the address. That's why. They want 5 Franklin Place. They don't want a Broadway address. For whatever reason, they like it. They have an entrance on Broadway. The building has a frontage and has an entrance on Broadway. Just to see, as an example of how out there this claim is, at the record at 189 to 193, this is a quote from their petition. Respondents have not responded, respondents meaning us, have not responded to the August 11th, 2020 letter. This is the letter that appellants wrote to the City of New York, demanding that the City of New York answer them within 60 days, or otherwise they would consider the city to have made a final determination, a self-executing directive to the City of New York to make a final determination of the fire department.
Yeah, they tried.
They tried. But it gets better, Your Honors, because this, I'm still quoting, the 60-day period specified in the letter has now expired. And despite repeated efforts by petitioners, neither FDNY nor DOT have taken any further action with respect to Franklin Place. Petitioners presume, therefore, that their decision is final.
And when was that dated?
Their letter?
Yes.
August 11, 2020.
Yes, and so they commenced this action December 19th, 2020.
60 days.
There you go. See,
I'm going to
they
start
adhered to
writing
their
letters.
letter.
Yeah, I'm going to start writing letters to the city and demanding things I want.
Yeah, well.
Thank you, Your Honors. Otherwise, we join in the arguments of our correspondents.
Well, let me ask you one quick question, real quick. I mean, putting all this aside, this just clears that alleyway. If they get what they want, the alleyway, with the other proceedings that we have already heard, essentially clears the alleyway now, right?
If they get this, yeah. And this court denied their appeal of a summary judgment, and the same, really the same idea.
So why don't we get the city to do the work for us? Right?
It's the,
I got it.
well, it's
I got
the
it.
fire department's job to make these determinations, but just one last point on this. The width of the alleyway alone would require a discretionary variance by the fire department. Discretionary. Therefore, not a ministerial, non-discretionary act which would allow them to get mandamus. This, frankly, we think it was a frivolous action when brought and should not have been brought in the first place. Thank you, Your Honor.
Thank you.
Good afternoon, Karen Fryman for Respondent 70 Franklin Place. I only want to make 3 very quick points. The first one being that it's not just the strength of the vaults underneath the alley that must be met in order for it to be a fire apparatus access road. There are other conditions set forth in the fire code that are set forth ad nauseum in all of the papers. It's not just that. The second thing is, and I might have misheard, and if I did, I apologize, but there's nothing in the record about any of the other parties on the alleyway preventing anyone from having access to their vaults to do a study. But the main point that I wanted to make, and it's really following up on Justice Oing's point, is that, you know, in their reply brief, the condominium says that the alley must be declared a fire apparatus access road, even if the fire department will not actually respond to emergencies on it, because that's within the fire department's discretion where to
fight fires. And they say that on page 4 of their reply brief. So why do they want it to be a fire apparatus access road if they don't even care if the fire department fights fires from the alley? And the reason is because it's been their goal, as they say in the record at page R232, that one way or another, and that's their words, one way or another, they're going to stop parking on Franklin Place.
I'm sorry, what did you say?
One way or the other, they say they are going to stop parking on Franklin Place. People, my clients, my colleagues' clients, have been parking on the street for hundreds of years. They have no ability, by trying to force, or 100 years, they have no ability.
Before cars? I mean,
Before cars.
Listen,
it must be a carriage, horse-drawn carriage.
The horse-drawn carriages were in Franklin
After
Place.
COVID, I have no ability to keep track of time.
There we go.
I apologize.
Yeah, Counselor, we're really familiar with
Yeah,
the
we
facts
got
of
it.
what's going on.
You know
But the other one was the motorcycle couldn't pass on the street.
No, just put up a couple of tables and have like a, some sort of bistro there, and you're all
Do
fine.
not give them any ideas. Thank you very much,
Thank you.
Counselor.
Thank
I
you.
appreciate it.
Go.
Yeah. Over the rest.
Good afternoon, Your Honors, and may it please the Court. Michael Contos from Wilkhouse under LLP, appearing on behalf of Respondent 373-375 Broadway LLC. I'd just like to raise a couple of points. First being, our client argues in its papers that appellants are equitably estopped from asserting the claims here. We have between January 2020 and March 2021 evidence in the record of over 175 cars owned or controlled by what we call the FP parties, the condo owners, the board of the condo's employees, parking on the alley almost every single day, even overnight sometimes.
Yeah, but counsel, let me stop you. Their petition is basically they want the FDNY to declare this alleyway a fire apparatus road. That's it, plain and simple.
Yeah.
Irrespective of how many cars park, I mean, you could park a 16 truck trailer in there. They're just saying they want it. My understanding of the petition is very simple. They want the FDNY to make a declaration. That's it, right?
They want one way or another to stop parking on that alley.
Yeah, they want it clear.
However they get to it. In this case, if the city will do their work for them, the better. But that's their ultimate goal, yeah. And they don't hide it. I mean, they have said one way or another, we intend to stop parking on that alley. The other point I'd just like to raise, I'd like to address Justice Owings' comment about horse carriages. Actually, we did have evidence that there were horse carriages parked on that alley. So it could possibly be, as my colleague said, 200 years they've been parking on the alley. I just want to remind the court that in this case, as Mr. Turkel pointed out, there was no final determination from which they could commence an Article 78. There just wasn't. They said to the city, you got 60 days or else we decide that we can commence an Article 78. Justice Hagler in the court below clearly saw through that, said there's no final determination here.
And there's nothing that's in any regulation or anything like that that says that the fire department has a specific period of time in which to act.
Nothing, Your Honor. If Your Honors have no other questions, I'd like to yield.
Thank you.
Thank you.
So, counsel, actually, let me put that question to you. Is there anything in the regs that you're aware of for the fire department that states that they have to make a determination within a specific time of an application or within a specific time that they render a preliminary determination?
No, I cannot cite anything in the regs to that effect.
So why, again, are we here?
Well, there was also a claim against the Department of Transportation. We're not pursuing on appeal. And we think we have a right to mandamus to compel, which is a little different than reviewing an arbitrary and allegedly arbitrary and capricious determination, where our position, as expressed in the petition, is that they have a ministerial duty to declare this, the fire apparatus.
So, counsel, are there in fact two entrances to the building?
There are two, yes. You can get into the building on Broadway, but the main frontage space of the building, as Captain Malloy stated, as we allege, is on Franklin Place. That's where the...
But is it within your purview to require the fire department to use one access point as opposed to the other in the event of a fire?
No, and we're not telling the fire department how to fight fires.
So there's no I don't get it, is I guess what I'm saying.
How they respond in any particular incident is up to them. But Franklin Place is the alley on which the main frontage space of this building is. It's where the main attendant lobby is. It's where the fire
I guess
alarm.
my question to you as a newbie to this case is, so what?
Well, that is where they intend to stage their firefighting operation.
But there's lots of buildings on Broadway that have but one entrance, and that is on Broadway, right? And you have two. So if the fire department fights fires on Broadway, and Broadway is strong enough to hold all the very, very heavy, hold up all the very, very heavy trucks and other equipment of the fire department, who are you to choose?
That's not a question you need to respond to. We know the answer. Thank you so much. Appreciate it from all of you. Thank you so much. Take care. Don't want to see you again. Gulf LNG Energy versus NCSPA.
I love you, man.
What is it? The Beverly Hillbillies? Y'all come back now. No, don't come back.
I don't know how I can top that, but I'll try.
You got a street too?
May it please the court.
You have a street too.
No, we just have a huge oil and gas facility that we're talking about.
Oh, yeah, you've got a gas facility.
That's right, they have a gas facility.
You got a gas facility.
And actually, I wanted to start, I'm Joseph Allerhan for the Gulf Appellant. Everybody comes to this court and says their case is really important, and every case is important in this court. This case, if we didn't say it in our brief, is hugely important to the construction of billion-dollar...
Every case is important to us, seriously.
I know, but I want to explain that the guarantee at issue here, Your Honor, without enforcement, a faithful enforcement of a guarantee, according to its meaning and intent, like any other contract, it's not a disfavored instrument under New York commercial law, a guarantee, this billion-dollar facility would not have been built. I have enormous respect for the commercial division, but occasionally, they do get it wrong.
So let me ask you this question. Let me ask you this question. There was an underlying arbitration, right?
Exactly, yes.
So was that challenged? Was that arbitration proceeding after the decision came down challenged by your client? Because that's the one that says, okay, this is terminated, it's done, because there's a frustration of purpose, or it's impossible to keep this going because of what's going on.
No, we didn't challenge the arbitration proceeding. In fact, we enforced it, but we were still hundreds of millions of dollars short.
I didn't say, I'm just saying, yeah, you're right. You enforced it because you got like $400 million out of that.
Right. But we're still out hundreds of millions. More importantly, the court below relied on 3 words: becomes due and payable. In the beginning of the very first of 2 paragraphs that determine the outcome here. And she said there's only one dispositive, reasonable interpretation. I would say we've established on this appeal, not only is there more than one interpretation, the very section that she completely ignored, 3.2H, mandates summary judgment in our favor. What does 3.2H say? 3.2H says there's an unconditional obligation, and it's not affected in any way, shape, or form by any one of 15 things. The contract could be terminated and the guarantee still applies. Or what's right on point here, H, if the obligee is released or discharged from performance as a matter of law, under 3.2H, the guarantee is still in effect and the 20 years of payments have to be made. The court never addressed 3.2H, but it's even worse. 3.1, the section the trial court did rely on, actually incorporates 3.2H in its last sentence. We put in an affidavit by the drafter. He said, I put that in because I didn't want there to be an argument down the road that if the obligee got off the contractual hook as a matter of law, that the obligor, the defendant here, skirts the guarantee and walks away. You know what the other side said? They said that was a mistake, that sentence. When has summary judgment ever been granted?
So, counsel, let me ask you this question. All right. So we have this agreement between the respondent here and your client in terms of leasing this gas facility, storage facility, right?
Not leasing, building. We built it
Okay,
ground up.
building the gas facility, right, from the ground up.
Yes.
And there is I gather, how do you get paid? You get paid on a
Monthly.
Monthly,
Monthly.
based on what, a lease?
No, there's in the contract, it sets the actual terms.
Oh, so
of
it's
payment.
like, okay, here's the debt, therefore, debt is going to be paid on a monthly basis.
Not debt. They're going to pay every month for the fact that we built this facility.
But it's
and they have
set,
right
the
to
dollar
use
figure
it.
is set. The
Dollars
dollar
is
is
set,
set.
correct.
Okay, so that's what you're arguing, that the amounts due and owing were already set in the contract.
Exactly.
Therefore, it doesn't matter if it's terminated or not, because the guarantee, my understanding of a guarantor is that I can only guarantee payment if the primary doesn't pay. And your position is, well, we have the numbers already there, so that it doesn't matter what the arbitration did. I'm owed the money.
Of course not. Think about the absurdity of the result.
Is that the argument?
Yes. Think about this, Your Honor. If, let's say there had never been an arbitration to start with in this case, and the shell subsidiary that was in the contract, the 20-year contract, just said, we're not paying. And then we moved to enforce the guarantee, and the guarantor said, oh, there's frustration of purpose under New York law. Would anyone argue that they could raise that defense under 3.2H? Of course not. The words are crystal clear.
But you didn't appeal the arbitration. So aren't you bound by the results?
No,
And you accepted the money that was awarded to you as a result of the arbitration, $462 million in costs for the decommissioning, and the guarantor was liable through December 31st of 2016 for the fixed fees. So you didn't have a problem with accepting the $462 million.
Your Honor, we put in an affidavit in opposition to the summary judgment motion, the Friedman affidavit, which explains in great detail that the arbitration was never at issue. If we had been made whole 100% in the arbitration, we wouldn't be here suing under the guarantee. We're out hundreds of millions of dollars. This wasn't a question of either or. We either accept the result of an arbitration or we waive our rights on the guarantee. ENI, the party here before Your Honors, wasn't even a party to the arbitration.
So, counsel, the monthly fees that we're talking about that are payable for 20 years, that's based on a specific dollar amount that was already negotiated for and put in the contract?
Yes, sir.
It was just a payout of 20 years.
No, it was negotiated.
Yeah,
And
I know, it was negotiated. There's a specific dollar amount negotiated in the contract, and I'll find it somewhere. I don't have it in front of me. And it was payable over 20 years.
Yes.
Bottom line.
Yes. Each month, a certain amount of payments, whether you use the facility or not. They got out of this contract, which, by the way, is pretty amazing under New York law, saying because of we started producing a ton of gas in this country, thank God, we don't need to bring in oil and gas from outside, so we don't want to use this $700 million facility you built. And they got off the hook. And by the way, frustration of purpose, that's a discharge under New York law as a matter of law. They didn't rebut our cases. The arbitration panel ruled. Everyone agrees this is a New York law case and that a frustration of purpose is a discharge. That's at the record 1010. It is clear and uncontested that the TUA is subject to New York law, including the rule discharging performance in case of frustration of purpose. So if they're right, what does 3.2H mean?
Yeah, but your position is that there were due and owing sums. Sums were due and owing. It was not the fact that the arbitration terminated the contract. It was already set in stone what was due and owing.
And believe me, the due and owing, they still owed hundreds of millions. The due and owing doesn't, let me say it this way, 3.1, which the court relied on, sets the stage. It just refers to the payments that are owed, and then it incorporates 3.2H. It's not the showstopper. The showstopper is 3.2H.
Thank you.
You have time on rebuttal.
Thank you very much, Your Honors.
I think you dropped a sheet of paper.
Good afternoon, Your Honors. Eleni Gogadze from Shepard Mullen for ENI SBA. The court below correctly granted summary judgment here.
Well, you know, I understand his argument. His argument, and the court below now analyze it as, there were no sums in due and owing anymore because the arbitrator in the arbitration proceeding terminated the contract and there was nothing left to go. But then he made a good point, and it triggered in my mind that in the contract that you guys had, there was a set dollar figure that was payable over 20 years. So in terms of, no?
Sorry, no, Your Honor, respectfully, that is not how the contract is set up. And that's very clear, that's not how the contract
So there is no set dollar figure?
No, and
Because you understand why that was concerning to me, because then there's a due and owing situation.
Exactly, and let me get to that point, because you were exactly right to ask that question. What they are asking here is for any SBA, the guarantor, to pay fees for the services they're no longer obligated to provide. And here's what's the problem with that. It's not dispute. It's not a disputed fact. Their witnesses admitted the following, that under the contract, the payment of the monthly fees were quid pro quo for the services to provided each month. Their witnesses admitted that, and and also, not only that, that's absolutely contrary to the plain language of the contract.
Well, the contract talks about reservation fee and operating fee. So how do we?
Yes.
Are those terms defined, and how do we know a dollar amount?
Yes, those terms are defined, but importantly, one of the articles that I would like you to refer you to is Article 11.6 of the TUA, which states that as long as either the customer or the guarantor is paying the fees, services are to be provided. And we asked the witnesses here. They testified exactly to the same.
So you're not, your client, I'm sorry. Your client was not on the hook to pay out for the loans that were taken to construct this facility then? That's something totally separate, right? The financing part of it, your client was not involved.
Absolutely, Your Honor, you are right on point. They, in fact, in the arbitration, that's exactly what they argued, what you just heard from Mr. Allerhand. They argued this contract should continue forward so that they continue to perform and ENI continues to pay. And
Counsel, let me ask you, was there any acceleration clause in the contract that said if I default, then they get to accelerate the entire amount due?
There's definitely no, in these circumstances, in the termination of the contract, there was no breach of any alleged. If there was any breach, then in fact, liquidated damages clause would come into play.
Right.
And here,
but they were never going to be entitled to accelerate the whole amount.
No,
right?
never.
They were only either getting the liquidated damages if it was a breach.
Yes.
And in the case of a termination, that was it. They were getting nothing more.
Exactly, and more than that, here, in fact, what they're arguing, Your Honors, is that they, under the termination scenario here that we have, that they should get paid way more than they would ever get paid under the liquidated damages scenario. So this is not the case of the home mortgage loan. This is not that you've performed and now all that is left is to pay back. What they did argue in the arbitration is that in case of early termination, which is of course what happened that the tribunal determined, in case of early termination, they should in fact, because they have performed up to that point, they should get paid all the fees going forward to the 2031. That's exactly the argument they made, and that argument was rejected. Instead, as Your Honors correctly pointed out, instead what they got is they got paid for the performance, partial performance. They got paid for, repaid back for the construction. They also got paid to pay back their debt. All of that is right there in their award. And one point, I'm looking here that my time is running up, one important point I want to point out, which they never address in the briefs below, or here on the appeal, or today in the argument, is Article 17.3 of the TUA. That article states that when the customer, so the ENI USA to the underlying contract, is a credit-worthy company, there's no guarantee to be provided. Their witnesses testified to that purpose of the guarantee here. Here, the customer was a special purpose vehicle. That's why they wanted. They testified to that. But moreover than that, if we look at the language of the 17.3, it makes clear that the guarantee agreement here was never to be operated in the way that they suggest. He relied on the affidavit that he referred, Mr. Allerhand, of their corporate witness, who testified that The purpose of this guarantee agreement was to operate independently, separately, irrespective of the obligations under the TUA. In fact, the language they used was that it extends beyond the contractual terminations under TUA, while 17.3 clearly shows that that's not how this was to operate. They've never addressed that issue, and therefore their affidavit, of course, that's clearly inconsistent with that article of the contract. Finally, Your Honors, what is really the bottom line, what is happening here, which is exactly how you pointed out, is that the reason why we are here today is that they do not like their arbitration award. Yes, they got paid for hundreds of millions of dollars for the cost to decommission the facility, but now they want to re-argue and undo the award. That ship has sailed. They don't get to do that. Your Honors, you do not have jurisdiction. No court has jurisdiction to undo that award, and they do not get to do that.
Thank you.
Thank you.
To be crystal clear, Your Honors, we are not arguing about the arbitration award. They weren't even a party in the arbitration. The guarantee was never decided. We reserved all our rights. That's a complete red herring. This is not.
Did you make the arbitration? Did you make the argument in the arbitration that you should get paid till the end of the contract?
Sure, of course.
And you lost that argument, correct?
Under the arbitration, but not under the guarantee.
So now, okay.
Right, in other words, I understand the logic of that is saying that the guarantee then is exactly the
So
same.
if they breached the guarantee, if they breached, you had two choices, right? You could sue them for what was due and owing, or you could get the liquidated damages, correct?
No, I don't agree. If they
Is there anything in there that talks about, I didn't see it, that's why I asked. Is there anything that talks about acceleration of damages through the end of the
guarantee is a little hazy on this point. It says money's not paid.
I'm asking you, is there anything in there that talks about you being able to recover everything for the 20 years as opposed to the liquidated damages or what is due and owing at the time of the termination?
There's nothing that says what's due and owing at the time of termination, Your Honor. I'm sorry, due and owing.
Due and owing by the
Your Honor, I would ask that the court look at the Rogers affidavit at paragraph 43, it's at the appendix 2886, where he explains what the only evidence that was put in on what due and payable means was we put it in opposition to summary judgment. There was no one on their side who was even there. I took the deposition of the person who signed the guarantee in Italy. He had no idea what any of it meant. He said he signed it because it was authorized by the board. And Mr. Rogers says at appendix 2886, all that what meant was the due and owing or the due and payable was a reference to the regular payments that had to be made over the course of time. By the way, the underlying contract, Your Honor, it's about, I forget, 50, 60 pages, single space. This is a case that was decided on summary judgment. There was no trial. Do you know how many facts they put in, even on just this argument? Testimony, we didn't comply. We did comply. We built the facility. I could show the photos. It's unfair to enforce the guarantee according to its intent. And I leave the court with one question. If they are right and due and payable just means, you know, you're off the hook if the underlying obligee is off the hook, what did 3.2 mean, and why did they put a sentence in which the trial court never addressed at the very end of 3.1, the paragraph they rely on, and say, you can rely on every defense in the world, obligor, if you get sued, but the one thing you can't rely on is 3.2H if the obligee is discharged. And they were discharged. Thank you, Your Honor.
Thank you. Thank you both. Herrera versus Highgate Hotels.
Good afternoon, Your Honors. James Dominy for the appellant. This is I think it's a pretty simple issue here. It's a cross motion to amend a complaint to add a third-party defendant and second third-party defendants as direct defendants. It's a simple negligence action. It's a slip and fall. The lower court's rationale was that the proposed amended complaint did not clearly show the changes and additions with respect to the proposed direct defendants, And that's the only rationale that they gave for denying appellant's cross motion. Like I said, this is a general negligence action. The third-party defendants who proposed to be added as direct defendants, they're clearly noted in the amended complaint. The allegations of negligence are essentially identical in the amended complaint. If you compare that to the original complaint in the action, the lower court's rationale did not state that.
Are you talking about Nexus and Subway, is that correct? I'm sorry, Nexus and Subway, is that correct?
Nexus, Subway, and Biswas.
Right. So as to Nexus and Subway, the court denied the motion stating there was no notice, no relation back. The relation back doctrine did not apply?
I don't think they said that. I think the lower court just said that the proposed amended complaint did not clearly show the changes and additions to be made. And I think that's, I don't want a hyper-technical issue. I know it's in the CPLR, but I think that you've got general negligence allegations that are basically identical in the amended complaint if you look at our original complaint.
Right, so I was going to ask, so in your original complaint, do you mention Nexus, Subway, and yeah, and who's the other one?
Biswas?
Biswas?
No, the original complaint is just against Highgate Hotels and the direct defense and Saul Goldman Investments.
All right, Biswas, and Nexus, and Subway. So in the original, you mentioned them?
They were not in the original complaint. They were brought in as third parties later on. They had a chance to fully litigate the action. All party depositions were held.
What is your theory of liability against Subway?
Theory of liability against Subway is that the lease does mention that they have an obligation to maintain.
And how many cases have you seen where an out of possession landlord
Correct,
who
Judge.
has, right? So let's be real about Subway.
want
Are
me
you
to cut
really
to-
pressing Subway?
I'm not pressing Subway.
All right,
I'm
the other
pressing
one, the Nexus,
Biswas
right?
and Nexus,
All
they are the tenants of the Subway sandwich restaurant. They had a responsibility, even though I am alleging Subway could have responsibility for it, the out-of-possession landlord, I'm saying Biswas and Nexus absolutely had a responsibility for the steps.
But you concede that Subway really is out of possession?
Judge, I don't want to concede that, but based on the lease terms, it's a strong possibility.
Okay, thank you.
Any other questions, Your Honors? And then I'll rely on my...
Yeah, you have time on rebuttal as well. Thank you.
Thank you, Your Honor.
First time I can breathe in hours. May it please the court, Glenn Kaminsky with Amity Demers McManus, counsel for Subway Real Estate Corp.
You're an out-of-possession landlord, you don't have any obligations under the lease, right?
He doesn't want to put the mask back on, so he wants to have time to say something.
I just wanted to say it appears you have my argument, so I will yield the rest of my time to my co-respondent, unless there's any questions.
I think we're good.
Thank you, Your Honor.
Thank you.
Good afternoon, Your Honors. May it please the court. Jennifer Coviello, I represent Mr. Biswas and Nexus BDS. Plaintiff's proposed amended complaint. First of all, plaintiff moved 4 years after the date of accident, more than 4 years after the date of accident, more than 1 year after the statute of limitations expired. Appellant knew he fell in a Subway restaurant in 2017. He had numerous opportunities in those 4 years before he moved to amend to sue Nexus, to find out who the franchisee was, to sue them, to...
For sure, but how are you prejudiced? You're the guy, all your people are the one testifying. You know what's going on.
Right, we're prejudiced because he let the statute of limitations expire without suing us. We were only defending against contractual and common law indemnification and contribution claims.
So
It's
how
different
are
claims between
you
plaintiffs.
prejudiced by being a main defendant? If it's your fault anyway, and I'm not saying that it is.
Well, it's not our fault anyway, because
But let's
we
just
did not cause,
assume
create,
that
or have notice of the condition.
you're in because of indemnification and contribution, right?
Well, we're
You're
not,
in
because the main
yeah.
defendants were let out.
Right.
So all the other derivative actions were done. The Highgate didn't owe anything to plaintiff because they won on summary judgment.
No,
Then
but at the time that they moved to add you, you were in. And so you were in the action at that time.
as a second, third-party defendant for derivative contribution and indemnification claims only.
Yeah, but you were still in. So you still had, notice, knowledge of what was going on and what the allegations were.
We had notice of plaintiff's allegations against Highgate, but not, he never made any direct claims against our client, and he had plenty of opportunity to in the 4 years from the accident and until he moved.
Okay, well, the allegations were that plaintiff slipped on oily substance, I think, as he was descending the stairs, making a delivery of Coca-Cola to Subway?
Right.
Right, so you knew that the allegations were that he, again, as I said, slipped on this oily substance on the steps. Is that correct?
Right, that he claimed he fell on it.
Right, so again, the question becomes, how are you prejudiced by the fact you knew what the allegations were?
Because it's now 6 years post-accident. We never got medical discovery because we were only defending a contribution and indemnification claim. We didn't.
But you were defending it on the basis that you were the one who caused the negligence, not just because you're your buddies or something. That was
We were
the whole
defending
point
on
of the
a contract,
contribution.
we were defending
Yes,
on a contract,
under a
not
contract that
negligence.
said that you are the one that caused this act, or you either had notice of it or whatever. It wasn't just like respondeat superior or anything. You knew that the claim was that in your space, that there was oil, that you were responsible as the lessee for the cleanup and everything, right?
Plaintiff never made those claims. The claims from Subway and Highgate were that if they're responsible to plaintiff, we're responsible to
And
that.
did you get all the discovery that was exchanged by the other parties?
We got some of the discovery that was exchanged by the other parties, but we never got authorizations for medical records.
But you could do that now, right?
6 years later, I mean,
Yeah, I mean,
doctors only have to
in
keep
New
records for
York?
7 years.
Have you seen a New York litigation lately
No,
with a lot of third-party defendants?
Yeah, I mean, we're not talking that, that there's been some spoliation of evidence or the evidence is no longer, I mean, this is, if you're talking about medical issues or damages, right? I mean, that's static in a sense, there's a snapshot of it. Well, I mean, what other prejudice that you can allude to? I mean, you pointed out to the medicals because you don't have the authorizations. They'll just have to give you fresh authorizations. What else do you have?
Right, the fact that plaintiff let the statute of limitations expire, he never showed any relation back to the original defendants.
Anything else? No. I mean, your statute of limitations, I mean, like my colleague says, you were third party in, so it's like, there's a relation back concept in the CPLR too.
I understand, but plaintiff or appellant never satisfied all the requirements to show the relation back doctrine applied.
So you got the medicals, you got the statute of limitations, what else do you have that's prejudice?
And that, the testimony to show that we did not cause, create, or have notice of the allegedly oily substance. Plaintiff couldn't even show there was an oily substance.
Is your defense any different now than it was when you were defending the third-party action?
Yes, because we didn't have to move on those bases because we were only defending contribution and
You got to step it up.
And
You
it
got to
was
step up the
based on-
defense a bit. Thank you.
Thank you. I dropped something, I apologize.
Your Honor, just briefly, I don't know if you have any additional questions. Absolutely, it does relate back since the third-party actions were commenced within.
Yeah, what took it, so let's ask. The only thing here is the time, right? The time after the statute of limitation passed. What is your explanation for that?
Don't have a good explanation, but under Duffy, this is a permissible, it's discretionary with the trial court to grant this amendment. And I think there's, as you,
That's
Your
a
Honor
breath
said,
of
there's-
fresh air, what you just said. I gotta tell you, that's a breath of fresh air.
I don't want to, blow smoke here.
I gotta tell you,
But,
man,
you
that's
know,
a
my main argument-
Concede Subway, huh?
That's something else. I gotta mark this moment, because I've never heard that
Yeah.
response. I commend you on that one.
There's no prejudice, note issue has not been filed. Defendants can still move for summary judgment down the road. There's absolutely no prejudice, absolutely no reason why the complaint, should we not be allowed to amend the complaint to add at least Biz Wassa nexus. Thank you.
Thank you. People v. Bo Coleman. What were you saying? What did you say? I went too hard. I say you got to step it up. Is that what Sally said? No. Oh.
Good afternoon, Your Honors. Jan Hoth for Appellant Bo Coleman. Mr. Coleman's request for an adjournment was reasonable, and the court abused its discretion in denying it. The court's knee-jerk reaction that Mr. Coleman was merely trying to delay the trial is belied by the record.
So we're at the eve of trial now, and we've already had the suppression hearings and everything else. He's been going back and forth as to whether he wants to go pro se or not, and now he asked for an adjournment. And he asked for an adjournment, I think, to review, in particular, the grand jury minutes?
Yes.
Which he had already been given, right?
Well, his attorney had been given, I believe he had been given them, and his attorney was explaining that he'd been bounced around from facility to facility and lost them. But the point here is that Mr. Coleman wasn't asking for days, weeks, or months. He asked for an adjournment to review the grand jury minutes.
And so these were voluminous. I mean, I've reviewed grand jury minutes in my past, and I know these were voluminous grand jury minutes. They were like 7 pages, right?
Correct. So,
yeah. And these grand jury minutes had already been used to cross-examine the police officers during the suppression hearing.
only one of the police officers, the second police officer, did not testify at the suppression hearing, and it was his grand jury minutes that Mr. Coleman wished to review. But the point being that he asked for an adjournment to review 7 pages. So what would the harm have been to say, okay, I'll give you an hour?
But why is that? Why would that be an improvident discretion, abuse of discretion, by denying it?
Because the court just automatically assumed he was seeking to delay trial.
Well, we don't know that, do we?
Oh, yes, we do, because the court repeatedly offered to delay the trial if Mr. Coleman would accept his offer of appointing a new attorney. He kept insisting, I will give the new attorney a reasonable time to prepare. Well, why shouldn't Mr. Coleman, as a pro se attorney,
because that new attorney had not been present during all of the past proceedings, including the suppression hearing, wherein Mr. Coleman had been present during all of the prior proceedings.
Yes.
But counsel, is there anything in the record where the court says, no, I'm not going to give you an adjournment because I think you're using this as a dilatory tactic?
Yes, the court's initial decision, when asked, the court first said, well, you should have asked me last week because then you could have had a whole week to review these minutes. And then the court went on to say that he had been sitting at the suppression hearing and had heard, was so therefore familiar with the facts, and then said, this is nothing more than a delaying tactic. Counsel then explained that he had been bounced around and lost his minutes, and the court said, well, he should have raised this a week before. And that's absolutely absurd. Mr. Coleman didn't have to move to represent himself a week before, as the court later decided his request to go pro se was timely. But it's important to note that Mr. Coleman was not seeking days, weeks, or months. He asked for an adjournment. The court didn't even consider an hour adjournment. The court said, no, you should have asked me last week. The court said, no, you were here, you're familiar with everything, and you're just delaying the trial. But that clearly was not true because then...
What, if any, prejudice was there to the defendant? Even, the court denied the adjournment request. But as it turns out, the officer in this case didn't testify for nearly 3 weeks afterwards. So the defendant had 3 weeks to review the minutes.
Your Honor, it's impossible, as the Court of Appeals has held, to ascertain the prejudice to somebody representing themselves who asked for an adjournment, reasonable request. It was not an unreasonable request, and then denied. We're now playing Monday morning quarterback to say, well, if we look at what ended up happening, it seems fine to us.
But see, Counsel, I did not understand that argument, because he denies the request for an adjournment. However, in actuality, there is an adjournment because it's 3 weeks before the officer testifies.
Your Honor, the trial started immediately after this request.
Right, but then wasn't there time after that? Wasn't there time in between the witnesses? Was it? That's why I couldn't find in the record. Was it immediate? Was it a one-day trial?
My understanding is that it just proceeded. He went pro se, he waived his right to a jury, and then they called the witness, and the witness whose grand jury minutes that he...
But DiMaggio didn't testify until May 28, 2019, nearly 3 weeks after the defendant had requested an adjournment to review the grand jury minutes.
That's quite, I'm unfamiliar with that particular fact. That was not...
The trial commenced on the same day that the court denied the motion for an adjournment. DiMaggio did not testify until May 28, 2019, nearly 3 weeks after the defendant had requested an adjournment to review the grand jury minutes.
So Your Honor is now adopting a harmless error analysis, because obviously the court couldn't know at the time that it was denying his request that he would have 3 weeks to review these minutes. He asked for an adjournment to review what everybody agreed was 7 pages of minutes. He didn't ask for weeks, days, or months, and he repeatedly turned down offers to adjourn the trial. All he would have had to do was say, sure, give me a new attorney. And then at the next court appearance say, no, now I want to go pro se.
But the question is the prejudice. Should we not look to the prejudice to the defendant? Your argument is that the defendant was prejudiced. He should have been granted the adjournment to review the grand jury minutes, and the fact that he was not granted that adjournment somehow inured prejudice to the defendant.
Correct, Your Honor.
Okay, but he had 3 weeks now to review the grand jury minutes based upon DiMaggio not testifying for 3 weeks.
Yes, but there is no harmless error analysis.
I'm not even looking at a harmless error analysis, really. I'm just thinking that in the scheme of things, he actually received what he wanted, right? He had the time to review the grand jury minutes.
But you're looking at the scheme of things with the benefit of several years having passed from the request. That at the time the judge was making its decision whether or not to grant his request, the judge had no idea that this was going to be delayed 3 weeks and that Mr. Coleman would ultimately get time to review these minutes. We have to look at this at the time the judge was looking at it.
Is there anything in any of the cases that states that when on the eve of trial, a judge denies a defendant's request for an adjournment based upon the fact that the defendant is requesting that adjournment to review 7 pages of grand jury minutes, which he has a copy of, which was used to question witnesses during a suppression hearing that he was present at, that the failure of the judge to grant that adjournment, that is error, which requires, I guess, a reversal, reversal of the trial.
No, this court has.
And let me just
held
say,
somewhat
doesn't People
similar,
versus...
although I would dispute some of the facts as related in your hypothetical.
Doesn't People versus Brown say that the decision to deny an adjournment won't be disturbed absent a showing of prejudice? So you do have to show the discretion whether or not to adjourn is tempered by a showing of prejudice. At least that's what I think People versus Brown says.
And all I'm saying, Your Honor, is that
you said you don't have to show any prejudice.
Correct, Your Honor. That's Monday morning quarterback. I'm asking this court to look at the judge's decision at the time the judge made a decision. It was an abuse of discretion as a matter of law.
And you said it was a hypothetical. I don't think it was a hypothetical. I didn't mean it to be a hypothetical.
I
thought I
apologize,
was
Your Honor.
relaying, no, I'm just saying, I thought that I was relaying accurately what had occurred. But you have time on rebuttal, so we'll hear from your adversary.
Good afternoon, Your Honors. May it please the Court. Carl Dubel for the people. This was not an abuse of discretion to deny this adjournment. First of all, the defense they requested an adjournment, but he never requested an hour like defense counsel is now. He just says, I need an adjournment to review these grand jury minutes. And there are a number of reasons why that isn't true. First, as Your Honors noted, the minutes were turned over the week before the suppression hearing began. So he had over a week to review them and discuss them with his attorney, who was still his attorney at this time. As Your Honors noted, there was only 7 pages, and there is a prejudice analysis here. The testimony from this witness, or his grand jury testimony, did not become relevant for over 3 weeks when he actually testified at trial. And if you look at how the defendant used those grand jury minutes, in my opinion, he used them effectively to cross-examine the witness. So there's absolutely no prejudice for the denial of this adjournment. Unless Your Honors have questions on the other point, there were 2 other points raised in counsel's brief, along with numerous pro se points. I will rest on my brief.
Thank you.
Thank you.
Your Honors, on page 25, I cite several cases from the Court of Appeals where they decided in some instances that it was appropriate to look at prejudice, and in other instances it was not. And it seems to me that the overriding theme there is that when a constitutional violation occurs, then you should not be looking at prejudice. Here, Mr. Coleman wanted to go pro se, desperately wanted to go to pro se, that he even ignored the court's office of adjournments to go pro se. And he was entitled to the effective assistance of his own counsel, which he claimed he needed an adjournment. We don't know how much of an adjournment, but adjournment. An adjournment that the court felt would have been appropriate for an attorney to get. That is a violation of his right to counsel, his right to present a defense.
So that's an unfair characterization, right? Because when you say that the court felt that it would have been appropriate for an attorney to get, that's an attorney that is unfamiliar with the case, as opposed to the defendant who is totally familiar with the case.
Yes, I understand that, Your Honor, but nevertheless, Mr. Coleman was now acting as his own attorney, and
Which he had been contemplating. He didn't decide this that day, right? There had been conversations about the defendant contemplating going pro se before he actually made the decision to go pro se.
Correct, and that was one of the factors the court, I believe, used improperly in deciding to deny the adjournment by saying, well, you should have just asked me last week, then you would have had a week to review these minutes.
See, counsel, I'm sorry, I still don't understand your point, because you said early on in your argument that the court could have granted him an hour adjournment. That the court could have granted an adjournment until the next day. Again, in actuality, 3 weeks later is when the case picked up again. So again, 3 weeks was, that was almost an adjournment of 3 weeks. So again, I think you need an analysis. There has to be some analysis as to prejudice and what prejudice there was to the defendant. And I don't see how any of the cases that you've cited, which I've read, I don't see the Court of Appeals saying that there's no instance where you would not consider prejudice. Thank you.
Thank you.
301 East 60th versus Competitive Solutions. We thank you both for waiting, although you really didn't have that much of an option, but we do thank you for waiting as you're the last case to be called.
Good afternoon, Your Honors, and may it please the Court, Jed Bergman for Appellant Cross Respondents Competitive Solutions. As Your Honor just noted, it's late, and I'll be brief. There are three key reasons that the plaintiff failed to raise an issue of fact as to specific performance, and the defendant was entitled to summary judgment. The first reason is that the
Okay, let's get right to the heart of this.
Yes, sir.
According to the contract provision I'm reading, the buyer has at its discretion, two exclusive remedies. One is specific performance, may seek specific performance, and two, get the money back. Those are the two exclusive remedies.
Correct, Your
right?
Honor.
Okay. So then it goes on to say that if the buyer fails in his action for specific performance, he's still allowed to get his money back.
Correct.
Right? Okay.
Correct, we agree.
So why is it then that, and the Supreme Court took the position that they had to decide the issue of uniqueness, which is why, specific performance couldn't be decided. But you're saying it should be tossed entirely. You're the seller,
yes.
right? You're the seller.
Yes, we're the seller.
I just want to make sure I'm talking
Correct,
to the right guy.
correct, yes.
Right. So you're saying it should be tossed entirely. Why?
Sure, the case should be tossed entirely because this was summary judgment, and the plaintiff admitted that these assets, these IARs, were not unique. To the extent the court below found otherwise, on de novo review.
Oh, so you're resting, your main argument is, okay, I don't think the record here shows that there's any dispute that the buyer was ready, willing, and able, and that the seller, according to the buyer, breached or didn't want to go through with the deal. Ergo, you have your counterclaims for fraud and fraud inducement, right?
Correct.
So that your reliance on this is that based on what the buyer said, that these air rights are not unique, therefore specific performance goes out the door because for specific performance, equitable remedy, you need to show uniqueness.
That's exactly right, Justice Owing. This is a case about the availability of specific performance.
Yeah, so here's my problem with that.
Sure.
If I were to buy that argument, right, that they fail to demonstrate uniqueness, then that would mean that they would have to take the deposit. That's their remedy then, is to get the deposit back. Doesn't that conflict to the provision that says they have two remedies, two exclusive remedies? Give me the product or take the deposit. By your analysis, you get rid of the get the product. The only remedy they got now is take the deposit because your analysis then reads out that exclusive remedy then.
Respectfully, I don't believe it does. The two options that the buyer had were to seek specific performance, and that's the right the buyer has exercised from the day it brought
Correct.
this action until the day that its lawyer stands here. And the contract contemplates the buyer might not be successful in doing so. Our position is the buyer should not be successful in doing so.
But isn't it because the buyer won't be successful because you don't get the certificate because you can't comply? Because if we read it the way that you say, the buyer never gets, and you breach, let's assume that you are the breacher, right? The buyer doesn't get put in the position it would have been had you performed the contract. So how could that be? How could that be correct? So it seems to me that the only way to read that is if you can't perform because you don't get the certificate from the HPD or whatever else, then the buyer can't seek specific performance, gets its money back, it's in the position it would have been had you not breached. But if you can perform and you willfully breach, then the buyer says, no, I want it, and I'm entitled to it. There's no extra thing that you have to show. It's just, I'm entitled to that remedy. That's what the contract says.
So, two important things to which Your Honor and I believe Justice Owing earlier referred. One is the concept of a willful breach, right? In cases like Solis Realty, where parties agree that willful breach brings a different remedy, this court upheld those provisions. What this contract says is if the seller fails or refuses to deliver for any reason whatsoever, this contract has no willful breach. It is motive indifferent
Okay, for any reason.
Yeah, but in fact, it's not, because you can't specifically perform if you don't have the certificate. That seems to me the most commercially reasonable and logical way to do it. You can't if you don't have the documents, you can't get specific performance. If the HPD refuses to give them to you, and they've agreed, if you can't do it, if that's something out of your control, it seems to me that's exactly what this says.
May I respond, Your Honor?
Please.
There are two sentences at the end of this provision in 8B about two different scenarios in which specific performance is not available. One is the HPD scenario. The other, which is a separate sentence that has to be given meaning, is that if the buyer is unsuccessful in pursuing its equitable remedy, the buyer has to meet the equitable test, the traditional equitable test. This buyer cannot, because the assets are not unique and damages are
See, that's where you're infusing into that paragraph equitable remedy. It doesn't say that. It just says fails in the action for specific performance. And my position is, I'm reading this language here that, yeah, specific performance is an equitable remedy, and that there is a uniqueness element to this cause of action, to this claim. But the way this contract provision is written, not so sure that uniqueness is a factor to be considered, which is why I would think that well, I'll ask the question later, so that's...
If I may just respond very briefly, Your Honor. Yeah. There are other provisions in this contract that have the sorts of language we're used to seeing about people agreeing that damages are inadequate and so on. None of those provisions appear here, and our view is that the plaintiff still needs to meet the traditional equitable test and cannot.
Thank you.
Good afternoon. May it please the court. Jeffrey Turkel for the Cross Appellant.
Counsel, would you say that the remedy of specific performance in this case is a contractual right?
Yes, it's contractual and equitable. Okay. Because we also take the position that based on Mr. Lagrada's deposition testimony, that he himself has established that they are unique because he has established that there is no way of measuring any economic substance.
Let me ask you this. If it's a contractual right, do we have to engage in a uniqueness analysis?
No, I don't believe so. I think, as if I may infer, as Justices Oing and Scarpula indicated, it's a contractual remedy. That's not part of the equation.
Yeah, because it becomes self-defeating if uniqueness becomes a factor to be considered, because you go to trial and they find out that it's not unique, you don't get specific performance, but then you've just been denied your exclusive remedy of specific performance. That doesn't make any sense.
Yeah, yes, I agree.
And then you resorted that your only remedy then is to get your deposit back. I don't want my deposit. I want the product.
Your Honor, I couldn't agree more. What the contract says is that we have these alternate remedies, okay? The problem that I have with counsel's position is that he says, as a matter of law, air rights can't be unique. As a matter of law, not these air rights, but any air rights on Earth cannot be unique. And then he says there's no such thing as a contractual remedy for specific performance as a matter of law. If both of those statements are true, then the remedy here was void ab initio, it's meaningless, it's without force or effect.
But let me say this, right? There could be a, if we found that it was equitable, right? Your argument was, even if we find that you have to prove that they're unique, that there is at least at a minimum a question of fact on that issue.
Yes, that's true, but...
And that's what the judge below found. Like,
yes,
as a minimum, there's an issue of fact.
Yes, I agree with that point. I think it would have been helpful if the court had explained what the question of fact precisely was. But what I'd like to address, since we have talked about it as a contractual remedy, is why, based on Mr. Lagrada's own testimony, that these air rights are unique. Remember, this was summary judgment on both sides. Both sides are moving for summary judgment on the issue of specific performance. They had to put all the evidence within their ken. In the Van Wagner case, the Court of Appeals held that an asset will be deemed unique where there is uncertainty in valuing it. And I just want to read the exact quote from Van Wagner, because it's really what motivates and what is dispositive of the equitable side of this case. What matters in measuring money damages is the volume, refinement, and reliability of available information about substitutes for the subject matter of the contract. When the relevant information is thin and unreliable, there is a substantial risk that an award of money damages will either exceed or fall short of the promise's actual loss. There is far less risk where there is, and I'm quoting again, a great deal of consumer behavior generating abundant and highly dependable information about substitutes. Mr. Lagrada's testimony proved every one of those elements, proved exactly why these assets are not unique. He said, and it's true, the sale of air rights are not recorded anywhere, and there is no title to search. He said that the only way to determine the prices of air rights is to talk to attorneys and brokers who operate in the air rights space. He consulted his own expert attorney and 2 of his brokers to find out, what is the value of my air rights that I'm about to sell, that I have an offer for? And he said, they came back and said, we're not aware of any sales. And I think what's really important to note is that this was during the depth of COVID. This contract was signed in April of 2021, at a time when the economy was in shambles, the real estate market was in shambles, prices had plummeted, and there was very little economic activity and a tremendous amount of uncertainty. And Mr. Lagrada concluded, again, this is his sworn testimony, that the lack of data during the COVID period was especially acute because, I'm quoting, the market had slowed down and that due to COVID, there were few, if any, market data points. The fact that there may be an economic substitute for these air rights, i.e. other air rights, that's only part of the equation that Van Wagner posits. You have to have an economic substitute and you have to be able to value it. The record indicates that there were no other sales regarding these air rights at this time. Or if there was a sale, there was only one. And that is not an abundance of consumer information. That is not a definitive statement as to what the value of the economic substitutes are. So I would say that on the equitable side, Mr. Lagrada's own testimony establishes that these air rights were unique under the Van Wagner test. Thank you.
Thank you.
So, counsel, let me just ask you a question. Is it your position that if the buyer can't establish the right to an equitable remedy, that they're done, that you get to keep the deposit?
No, Your Honor.
Oh.
No, the deposit, if the buyer has the right to seek specific performance, we don't believe that there's a separate thing called a contractual remedy. People can stipulate to elements, but it's always an equitable remedy. If they fail to meet that showing, which they failed to on summary judgment, they get their deposit.
Well, so how do you explain all those cases where everyone says in their contracts, we agree that this is, we're not going to fight about this. To me, this is exactly that. We're not going to fight about whether or not this is worthy of specific performance. That's why we're putting it in. I mean, that's clear. That's, all right.
With respect, Your Honor, if we can just talk about the contract for a minute, because this is sophisticated parties, experienced counsel. Section 8B, the section we're talking about here, just says seek, it doesn't say receive. Section 8A has the sort of stipulation.
Why put it in unless you know that there's going to be a question? You could just say, seek my remedies, or take, that is exactly right. The reason why you put in seek specific performance is because the parties don't want to fight about whether or not they can seek it. And that is why it's put specifically into a contract. But you're saying here it's something different, as opposed to all the other contracts would say, you can seek specific performance. We don't want to have a fight about it.
Those other contracts tend to say things that other provisions in this contract say, like the parties agree the asset is unique, like the party shall be entitled to seek, claim, and receive, which Section 8
Well,
says.
I would tend to agree with you in terms of the uniqueness, because that's usually a factor in specific performance. But the contract language here is so, to me, it's very clear. It says you got 2 exclusive remedies, specific performance or you get your money back. And by buying your argument of uniqueness having to be a factor, right, and that and based on your argument that the seller or that the buyer said it's not unique, therefore I'm entitled to have that specific performance claim dismissed, that then forces the buyer to accept getting your money back as the only remedy. You've just literally cut out a remedy that he bargained for.
The buyer,
right? Do you follow that?
I follow it. I don't agree with it because the buyer litigated this whole case, and the fact that on this summary judgment record, the evidence the buyer put in did not suffice to establish that it prevails in that action. The contract contemplates that. That's the right the buyer had. That's the right the buyer exercised.
Only if uniqueness is a factor in this particular case. That's about it, right?
Which we believe it is, but if it's not, if the word seek means entitled, then that's correct. May I just say one minute on Mr. Lagrada's testimony, please?
No.
Okay.
But thank you.
Thank you, Your Honor. Have a good evening.
Oh, wait.
Oh, did you have? Oh, I forgot you. See, now I'm getting like the others. I forgot you.
Well, you can probably stand up again, Your Honor, because I'm going to rest on my briefs unless the court has any questions.
Oh, thank you.
Thank you.
Thank you. Thank you both.
Court is over. You have 2 coming out.
Oh, you wrote a terrific brief. Thank you. I think you write very, very well.